Go fuck yourself, off you flock, flock up and die. What the flock? Go fuck yourself, off you flock, flock up and die. What the flock? Dear Bruce, go flock yourself, Bruce. Don't email me again, serve me or shut the flock up. Dear Bruce, go flock yourself, Bruce. Don't email me again, you may serve me or don't, but shut the flock up and leave me alone. All the best, all the best, all the best, all the very, very best. Megan Fox, go flock yourself, off you flock, flock up and die. What the flock? Go flock yourself, off you flock, flock up and die. What the flock? Dear Bruce, go flock yourself, Bruce. Don't email me again, serve me or shut the flock up. Dear Bruce, go flock yourself, Bruce. Don't email me again, you may serve me or don't, but shut the flock up and leave me alone. All the best, all the best, all the best, all the very, very best. Megan Fox.
Go fuck yourself, off you flock, flock up and die. What the fuck?
Go fuck yourself, off you flock, flock up and die. What the fuck? Every case I find has these weirdos in my inbox. Crazy lawyers who sue people who should be locked in a zoo. It's a free parade and I'm sick of their games. Throwing fits over speech only makes them look weak. There's only one response for these weirdos in my inbox. Go fuck yourself, off you flock, flock up and die. What the flock? Go fuck yourself, off you flock, flock up and die. What the flock? What the flock? Dear Bruce, go flock yourself, Bruce. Don't email me again, you may serve me or don't, but shut the flock up and leave me alone. All the best, all the best, all the best, all the very, very best. Megan Fox.
Flock off.
Go flock your sky, off you flocks, flock off and die. What the flock? Go flock yourself, don't ask why. Off you flock, flock this guy. Go flock yourself,
Off you flock, flock up and die. What the fuck?
go flock yourself, off you flock, flock up and die. What the flock? Go flock yourself, off you flock, flock up and die. What the flock? All the best, all the best, all the best, all the very, very best. Megan Fox.
This flocking guy. Flock him, flock them, flock everybody. Off you flock. Welcome back to this show, everybody. That was a long intro. I played the long one today, Tug. What did you think? Did you like that? Did you fall asleep?
Indeed. I'm still, I don't know the delay, man. I'm still like, wow, are we live? No, I'm just playing.
I know. I'm sorry. I have Wednesdays has become a very difficult day for me with driving kids around. Today I had two events, a baseball game and the other one's youth court training. And so, it's just, I got to be two different places at once. Luckily, Spawn helped me move them around. But I was racing back home to get to the live stream. That's why it was scheduled for 8:30. So anyway, thanks everyone for being here. And I think maybe a bunch of you don't know I'm streaming right now because looks like not all of you have arrived yet. So share the stream, let people know that we're live right now. Because maybe they thought I wasn't coming because it, 8 o'clock came and went. We'll see.
Yeah, that happens. I don't know. Actually, I had somebody tell me today that when we're on here, they don't get notifications all that often.
Yeah, they're complaining about that to me as well. That just reminded me I didn't share it to locals because that's normally how I get around that. So if you go to meganfox.locals.com, when I'm normally doing what I'm supposed to be doing, I will have shared that there. I'll go do that now, though. And if you can follow me at Locals for free, you just can't leave comments or do the live chat, but you can see my posts, which means you'll see my notifications when I'm going to go live. And I always, except for today, post when I'm going live, and I'm doing it right now. So it will be there for everybody to see the link.
Every single time I do it. Well, except for this one.
Well, except for today. I mean, sometimes I'm late, but why won't it let me publish? Oh, that's right. Hold on. Typing. There we go. And we're published. And there's a live chat. So those of you who do follow me on Locals, you got your live chat where you can drop your GIFs and stuff and memes. That's always fun. Hello, people of Locals. All right. So that's done. And also don't forget to check out the new super tips because those are a lot of fun. If you go, it's pinned to the top of the chat. supertip.gg/Megan Fox. And when you send a tip there, a fun little AI voice will read it. Let's see. Cynic in Chief sent one.
Stop talking about John's rooster. Talk about my rooster instead.
Yes, my rooster always has issues. And Brazilla's Realm sent $5.
Hurricane Laura is about to blow through your area. Please seek shelter as anyone caught in her path will be blown away.
Hurricane Laura. I love it. Okay, so super tips are fun. And you can also send the ones that are just the text that I can read. It's up to you. And what's cool about super tip is that they only keep 10% of the proceeds. The rest of it goes to the creators. And we really like that. And it supports the show. And it's a lot of fun. We should have more voices coming up soon because the company, they're back from their Vegas thing. So hopefully they'll be doing those new voices. I've got a bunch in the hopper. So no chat. Tug's birthday is tomorrow.
Yep. Tomorrow. 15th.
Yep, the 15th, just like mine, except 1 month later. I'm
Yeah.
April 15th and he's May 15th, which is really kismet, It's very strange, Tug.
It
That we're
is.
both
It's very
15.
Weird. It's interesting.
Very weird.
You know what? Middle of the month, baby. That's good though.
It's very weird. But yeah, so I have so much cool stuff to go over tonight. By the way, one of you on Rumble was asking, when are you going to get back to finishing Shara's deposition? We will definitely do that soon because that thing is really interesting.
We also have time now, as we found out today.
That's correct. Do you have that order ready to go?
Let
I
me-
actually haven't pulled it
give
up.
me-
If you want to pull
Yeah,
that up,
give
we
me
can-
1 second. I'm screenshotting 2 things out of it. So
Sure.
I will have
We've
it in just a
got
minute.
we've got a new order on the docket. There's been motion on the case because we thought that the 30-day stay was up as of today. And we
Yeah.
were expecting motions to be filed that we would be reading. Unfortunately, the judge decided to stay the case indefinitely.
Yeah, which is great. Well, I mean, we still don't have the decision on what's going on with the judge. Like we've talked about, we all had a conversation about this, try to see exactly what we thought about that. But we still haven't had a district judge come in and say, he's going to shoot that down. There is no way that that's going to stay. But Bruce, he asked for him to be removed. So there is a process for that.
Yeah, my guess is that's what he's waiting for, and that's what he needs the extra time for. So this order came in today. It says on April 14th, the court stayed this case for 30 days to allow defendants time to locate new counsel. That stay is set to expire on May 14th, 2025. The court, however, will sua sponte, which means of his own power, of his own, without being prompted by a motion, will extend the stay until it holds a status conference with the parties regarding the status of defendants' representation by counsel and other remaining issues. Accordingly, it is ordered that the court's previous stay is extended and that this case remains stayed until further notice. And I found this to be interesting that the order itself contradicts the paragraph above, because the paragraph above says it will be stayed until we have this conference.
Mm-hmm.
This one says it will be stayed until further notice.
Yeah.
That's different.
Mhm.
And then number 2 says, by separate order, the court will schedule a status conference with the parties to ascertain the status of defendant's representation by counsel and discuss other issues, which the judge then did.
You know, I really, like we were talking about, I really hope that it is brought up that they fired their counsel. He did not step
Right.
down, and they were fired. So as far as the defendant's representation by counsel, that's their bad. They terminated the person. That's how it read. That's exactly how he wanted to get out of it. So he did not face sanctions. So if they have not found somebody that's going to step into the breach, I mean, it's certainly not Jeremy Hale's fault. That's the person that
Right.
is they're seeking some kind of remedy for this stuff. And he's supposed to be able to, he's supposed to have not just a trial, but he's supposed to have some kind of, what did they complain about the judge did? He complained about delays. He complained about it himself. These people need to
Mhm.
make this quicker. So instead, the judge has this. Again, it's probably him waiting still, but we still haven't seen anything on the Bruce side. I mean, Bruce was able to throw up the middle finger, and he thinks nothing's going to happen to him. So, this judge.
And I really can't put on my court prognosticator hat anymore with this guy. I can't. I don't know what's going on. I don't have any guesses at this point. It's all up in the air. My only guess is that he's waiting for that motion to vacate order from the Chief Justice. Now, I will tell you, because I know that the audience wants to know, when will that motion be ruled on? I did submit a press inquiry today to the clerk asking if there's a deadline for the the district judge to rule. Because there usually is and it's been 30 days. I counted. It's been exactly, as of today, 30 days since the motion to vacate was assigned to the district judge. That's when I started counting. It was assigned on April 14th, approximately, and it's been exactly 30 days. So I did put in a request. I have had communications with that clerk before, and so I expect to hear back from her probably tomorrow. She's pretty good about getting back to me just to find out, is there a deadline? Is it 30 days? Is it 45? But there must be a time constraint. You can't just leave a motion out there for the district judge forever.
No, there has to be some kind of time constraint on that. Surely. I mean, there's a rule for everything in the court. So there has to be some kind of rule on that.
Yeah. So I will get that answer for you guys. Can you pull up the status conference hearing date thingy?
Yeah, let me say, there may be stuff in there that needs to be redacted. I haven't redacted it yet. Yeah,
Well, actually, we don't even need to see it. I just know that they set it for May 29th, which is
Yeah.
hilarious because that is also the day of Laura Owen's arraignment, which I will be covering live on my channel.
Yeah, I can lock in on that without the bottom.
Okay.
I'm not going to show the bottom of the
Okay.
document just to say.
Yeah, Laura Owens is going to be arraigned for her 7 felony charges in Maricopa County on the same day, May 29th. That's going to be a big day. So here we go. We have conference call. It's going to be a phone conference, so it will be on Zoom or whatever, WebEx. Call instructions scheduled for Thursday, May 29th at 11 a.m. Central, 12 p.m. Eastern, before Judge Blytho.
You know, it's weird. We didn't even get an order for 139. When he struck the John Cook entries into this, they he didn't even actually put out a document for that. That's strange, isn't it? I mean, typically you'll have
He's just. I get the
docket.
feeling that he's really tired of this case. I get the feeling he might want to be removed from it. But again, like I said, I don't know anything about. I've lost my ability to prognosticate what's going to happen here. I've completely lost my ability to do it because this judge is just. I can't read him.
God, he's dragging ass is what he's doing. Now,
He is
you
dragging
know,
ass.
something should have happened with Bruce. I mean, just to be honest, it doesn't matter, you know, if they're waiting on something. He could have noted that, hey, we are waiting on this. He could have said that. He could have said it in an order or anything else. Again, instead, he brings up, look how he worded this filing here. You know, it's so bizarre considering, again, these people out there, they've done some pretty awful shit. Bruce did some pretty awful shit. Then he just drops out. He's just like, hey, I'm done because I'm not going to show up and listen to you, Judge. I'm not going to do it at all. I would rather quit than show up. And the judge is like, oh, okay, whatever. He's kept his mouth shut so far.
Yeah, and what I've discovered and what we're going to talk about tonight, Shizzy has been working really hard to uncover what Bruce has been doing in his, you know, throughout the years. And he's uncovered some amazing things. And one of the things that he uncovered was this Judiciary Committee meeting in Connecticut, where the appointed judges that were appointed by the governor were going in front of the Judiciary Committee for their not appointed, what's the word for when you put somebody up for something?
I don't know.
It's not
You
an
say
appointment.
one more time there.
I know. I don't know why I'm
Sounds
not.
you're
It's
gonna
like
fit.
a reassignment. Like, you know, you put it back up for the vote, right? They have to get voted on again. But they're going to be they're going back up, and they're in front of the Senate, and the Senate is asking them. Senators are asking them questions about their they were reaffirmation nominated. Thank you, Goosebump. Yes, renominated.
Megan goes re all the way home.
All the way home.
I don't know. It cracked me up for some reason because you just got stuck there. I have those moments where I get stuck at it.
I did. I got
I don't know.
stuck.
It just made me laugh because you're like re.
Listen, it's been a long day. And I came home to more dog, you know what, all over the floor.
That's
because
awful. Gross.
He's got another stomach ache for some reason. And now, right before the show, I was mopping with bleach. Oh, God. The bleach probably got into my, my brain cavity, and that's why I can't think of words.
You're like, I can't make.
I can't even think of the word brain, like a brain cavity. What the hell even is that?
A brain cavity.
What's a brain cavity? I've been inhaling bleach. Can you tell? Yeah, the rooster. You guys, the rooster's fine. The rooster made it through the night. We put him in tonight. He's fine.
So he's not the dumbest rooster ever.
No, he's not. His name is Gus, by the way. Gus is fine. So anyway, what we're going to look at is we've got some information that Bruce went after yet another judge. So in front of this Judiciary Committee, they're asking all these judges who are up for nomination again to talk about their cases, and they have questions. They ask them questions about complaints that are filed against them. And this one judge, the Honorable Dan, I don't know if it's Shaban or Shaban. I'm not sure how to say that. How would you say?
Shaban. I like Shaban.
Shaban. Okay. Shaban. So we'll say Shaban.
That sounds like my Southern. It agrees with my Southern, Shaban.
Yeah, we got it. So I looked this. So his name, Bruce's name, comes up in this when they're questioning Judge Shaban. So I just decide, well, I'm gonna Google it and with Matskin's name and see if he's made comments about this judge. Sure as fuck, I find another article that this idiot has written in 2012 about this judge. That New Haven Register lets Manskin write on their forum like he's a columnist. I don't understand who he knows at the New Haven Register, but they let this guy put all his grievances all over their paper. So here's one. We've never read this. I love his headlines. Lawyer can't be silenced in fight for justice. Now, of course, the lawyer he's talking about is himself. Such a strange headline to write about yourself. And if you notice, he's always in a fight for justice, right? He's always being wronged by the system somehow. So we're going to read through this, and then we're going to go over to the judiciary transcript from that Senate hearing and hear what Judge Shaban had to say. Connecticut's Code of Judicial Conduct states a judge shall apply the law. But when a judge apparently refused to apply the law and I protested, I was the one subjected to professional opprobrium and threats of official discipline. Interesting. So yet another judge, and this is, by the way, I don't believe this is the mac and cheese case. This is a different case. In August of 2011, I and my client, which is grammatically incorrect, you would say my client and I, not I and my client. That's completely wrong.
I am my client.
I and my client. Like, are you kidding me? Why does the New Haven Register not edit these things? In August, I and my client, an incomeless company. What kind of company has no income? That's a bad company.
Yeah.
An incomeless company seeking several $100,000 for a title insurance claim were shocked when Superior Court Judge Daniel Shaben, in his written opinion, deciding the case of Bristol Heights v. Chicago Title Insurance, omitted Connecticut law governing insurance policies. You know what? I'm going to look this up. Tug, while I'm reading this, look up Bristol Heights versus Chicago Title Insurance and see if he papered the fucking docket the way he does everywhere.
Bristol Heights versus, what was it? Bristol Heights
Chicago
versus
Title Insurance. In his written opinion, deciding the case of Bristol Heights versus Chicago Title Insurance Company omitted Connecticut law governing insurance policies. I and my client, oh my God, is he serious again with this? Oh my God, you know what this makes me want to do? I can't with this. It sends shivers up and down my spine. I and my client had relied on this law in litigating against the insurance company since 2006. 1 month earlier, Shaben had issued an opinion in another case applying the very law omitted from his decision and ours. That law requires him to interpret an insurance policy as a whole and to award coverage if supportable under any rational interpretation. Shaben's decision did not mention, let alone interpret, the policy provisions we relied on. He denied a reconsideration motion in which his own prior decisions were cited without a hearing or reasoned opinion. Why Shaben acted so disdainfully toward us is beside the point. A judge must apply the law. No lawyer I've discussed this with could recall another trial judge issuing 2 written decisions nearly contemporaneously governed by the same law, applying the law in one and ignoring it in the other, despite it being prominently cited. In February, I wrote an article in the Connecticut Law Tribune, Judicial Robitis, Confusing Power and Discretion, in which I described a judge ignoring the law as an abuse of power. Then, on March 2, I testified before the legislature's Judiciary Committee against Shaben's reappointment for another 8-year term. I'd been encouraged by the comments of panelists at November's Connecticut Bar Association Judicial Independence Symposium, including the Judiciary Committee co-chairman and current and former Connecticut Supreme Court justices, each attesting to the relevance in judges' reappointment proceedings of the very issues I raised. A whole sub-profession of lawyers, those who invest their time in cases for parties without financial resources, are at risk when they cannot rely on the judge to apply the law, I testified. I like how he quotes himself. And when these lawyers disappear, so does access to the courts for the people who need them. Oh, did you really, though, do it for free, Bruce? Or did you do it on contingency? You don't go up against Chicago Title without a contingency agreement.
We'll see. I wonder how long he's pulled this. I'm doing it for free, and we're finding out. Actually, you weren't. You were, yeah.
Well, actually.
Yeah. I wish I could pull those up here.
I know. I wish we could too. I don't have those. God, only 2 of the 40-plus committee members, about half of whom are practicing lawyers, voted against Shaben's reappointment. The efforts to silence me had already begun. Oh, he always thinks someone's trying to silence him. This is paranoia beyond anything I've ever seen. The day before, the CTN network altered its March 2 schedule, eliminating coverage of the judicial reappointment hearings, although it had covered 2 prior hearings in February. He actually thinks they eliminated the coverage because he was speaking. You got to be kidding me.
Man, that's some ego right there, you know?
Bruce, nobody knows who you are. Then, the Tribune's editorial board, chaired by former state Supreme Court Justice Joette Katz, one of the symposium panelists, harshly criticized me for my Tribune article, asserting in a March 12 editorial that I directly attacked a judge. Sounds like I would like this person, even though Shaben was not named in my article. The editorial insinuated I had an unspecified personal agenda. Oh, yeah, that seems reasonable.
Do tell.
Next, the statewide Bar Council's office called for an investigation into whether my article warranted discipline against me. The state court rules of so another disciplinary? This is another disciplinary referral. Oh my God, the state court rules of professional conduct prohibit false statements concerning the qualifications or integrity of a judge. Recently, I received notice that a grievance panel voted not to initiate disciplinary proceedings, from which I infer they determined my statements were true. Oh my God, no, Bruce, that's not what that means. What it means is they decided it wasn't worth it for whatever reason to go after you. Not that anybody's statements were true or false. There's no way that them just saying we're not going after this. That doesn't mean that they're saying what you said was true. They're just saying we're not going to deal with this. We don't want it. Why such responses to my protest? Might the judicial elite be concerned about perceptions from the fact that the insurance company's counsel is the spouse of Connecticut's Chief Justice? Not only did Shaben ignore the law in ruling for them, but in 2009, then Superior Court Chief Civil Judge Arthur Hiller ordered the case transferred, resulting in a 2-year delay. Of the many cases Hiller transferred, only his notice in our case omitted the opportunity to object. Yeah, probably because you already papered the case so much that the judge was like, no more out of you.
Indeed. Seems like, again, something that happens quite often.
Quite often to him. Before the case reached trial in 2011, Bristol Heights owner died and its expert witness became unavailable. Shortly after trial, the company lost its land in foreclosure, putting it out of business. I am considering a lawsuit for the chilling of my free speech from the investigation, whether to discipline me. I asked Assistant Bar Counsel Fran Mickelson-Dara, who wrote the letter requesting the investigation, at whose direction she wrote it. She responded, I don't recall. I'm also considering a complaint against Shaben with the Judicial Review Council to see whether a judge can refuse to apply the law, as Shaben apparently did, without repercussion.
Do you think he thinks he gets paid by the word?
Probably. Only a meaningful response from the council will prevent this sort of intellectual dishonesty from becoming so embedded in Connecticut's judicial culture that the law no longer matters. Only the judge does, and whatever motivates him or her. Oh God, Bruce, do you ever stop whining? Ever? Do you ever go before a judge that doesn't do you some kind of harm or wrong? It's to me, it's strange that a person like him has nothing but bad luck with judges. To me, it makes it less credible, don't you think?
Yes, very much so.
He never has anything good to say about any judges. Never. Did you find the docket on that case?
I got distracted by something I found. I found something else. I'm trying to figure out what it is. It has him talking. He's speaking to a bunch of chairmen for something, for a judiciary committee. And I'm like, what is this? What have I just stumbled into on accident? So, mark this. I forgot what
I hear the dog crying. Hold on a second. I want to make sure the kids take care of him.
Yeah, I kind of forgot I was doing something else. I was like, oh, whoops.
I found it. Hold on.
I'm just curious what this is, because I found a government. You know, it's on the CGA, Connecticut Government 2012, and it's got Bruce talking about something, but I don't know.
Hang on, I'll be right.
So that's me. I was like, what the heck? That was weird timing. Yeah, apparently there's a lot of stuff though out there, folks. If people start going through it, there's actually quite a bit. Like it's a little gold mine to check into. Freaking Shizzy though. Shizzy actually run across, I don't know, all kinds of different items. And when you start looking, it looks like who knows, there may be more articles. I mean, God knows what's out here. So I'm marking this real quick. I need to go back through though.
All right, I'm back. Crisis averted. Okay. All right, so let me take this down. So interestingly, I found, let's see, I did find it. I don't know if I can see the docket on it yet because I'm not sure how many documents are involved. Maybe Justia will have it. Looks like the ruling was granted in part, denying in part, motion for sanctions, granting in part, motion for attorney's fees. Holy crap. Court imposes monetary sanctions on attorney Zimmerman in the amount of $5,000 to be paid directly to Chicago Title. I wonder if Bruce worked with Zimmerman. Looks like Chicago Title got sanctions. Huh. Maybe Bruce was off the case by then. Let's see.
I don't know. That's what I always wonder with these. Just jumping in and looking at them. Sometimes I wonder exactly what's happening there.
This should be interesting to read through. This is the first time I've looked at it, so I don't know what I'm looking at. So I need to take some time to read through it. But I have a feeling that, of course, what Bruce says is the truth, right, is highly subjective. So let's go over to the transcript from the judiciary hearing because it's really something. So Tug, you and I are going to read the parts of the senators and the judge. And how about you be the senators? I'll be the judge. Here we go. Here it is. All right, we're going to start here. All right, thank you, Senator. Good afternoon, Senator Coleman. This is Judge Shaben speaking. I would like to thank you and the members of the Judiciary Committee, along with Senator Fox. Hey, Senator Fox! I like it, for giving me the opportunity to appear before you today. I'd also like to thank Governor Malloy for his confidence in nominating me for a second term as a judge of the Superior Court. It has been an honor and a privilege for me to serve the citizens of the state of Connecticut in my capacity as a judge. Following my appointment in 2004, I was assigned to G818 in Bantam, where I handled both the criminal and housing dockets. I was next assigned to New Britain Judicial District for a year, where I heard civil matters. For the next 3 years, I was assigned to the Danbury Judicial District, where I heard civil and housing matters. Following my time in Danbury, I was assigned to the Litchfield Judicial District as the assistant administrative judge, and while there, I heard civil and family matters. I was next assigned to the complex litigation docket in Waterbury, where I currently sit and have been there now for almost 2 years. During my tenure as a judge, I have served as a member of the Public Service and Trust Commission and have frequently been a speaker on behalf of the judicial branch before various public organizations and schools. Now I have found all of my assignments both challenging and rewarding in every way, and it has been an absolute pleasure to work with such talented and dedicated colleagues. I would also be remiss if I did not acknowledge the wonderful clerks, staff, and marshals that I've had the good fortune to be associated with, and who have provided such excellent support to me and other judges in the effort to execute our duties. During my time, it has been my goal and practice to treat both those who came before me and those who work with me with the same dignity and respect that has been kindly shown to me. It is my sincere hope that you will allow me the honor and privilege of serving the citizens of the state for another term as a judge of the Superior Court. I thank you for your kind attention and consideration and would be happy to answer any questions that the committee may have. Yes, Flux, this is in Connecticut. The Judiciary Oversight Committee is interviewing judges for reappointment. All right, Tug, you are Senator Coleman.
I don't even know what he's supposed to sound like. I'm just going to play him normal. I have no idea. I have a quick question. I'm just curious as to how one gets selected to preside over this complex litigation docket.
That comes from the Chief Court Administrator's office like any other assignment. I can simply tell you that I'm not privy to the machinations that may go on within the office, other than the fact that I was approached and asked if I would have an interest in sitting on the docket. Particularly in this instance, because I was filling a position that was vacated by Justice Evely, who's now on the Supreme Court, and there was an opening there. And I was approached by the office and asked if I would be interested in taking on that assignment. And I indicated that I would be, and basically I'm a foot soldier. I'll go wherever I'm told to go. So it was presented as an opportunity to me. I should put it that way, and I agreed to do so.
I'm a foot soldier. I like that. So
you could join the Fox Den.
Exactly. So this was not necessarily another case of an offer that couldn't be refused. That's awesome.
Oh my God. We did not know this was coming. I didn't
that's some
pre-read this.
Godfather-y shit.
There we go.
There, Fox Mother.
No.
Yep. That's what it sounds like. I think he's saying nope on the docket because he knows what'll happen. Okay. So how do you enjoy that assignment?
It is a unique assignment, I must say. It has its own burdens and benefits, and the benefits are that it is almost akin to being like a federal judge, where you have more control over your docket and how things are handled, and when hearings are going to be held, etc. The burden of it is that sometimes the sheer size and volume and complexity of the cases can be almost overwhelming. And I think the docket is very well designed for its purpose in the sense that you want to have one judge assigned to it from the beginning to the end, because the amount of time and effort that needs to be put into a particular case on that docket can be overwhelming. And it would be difficult to handle in a piecemeal sense by different judges coming in at different times, like, say, on a regular short calendar docket or matter that works way through a regular docket. The insight that you obtain in handling a case by being familiar with it from beginning to end is invaluable in handling such a case. And part of the burden is the sheer, sometimes size of it, as I mentioned before. Boy, does this sound familiar.
This mofo talks a lot. I was just thinking, man, he actually gives some very good answers for stuff, to be honest.
Yeah, and it's clear and easy to understand.
It's concise.
And
he sounds
good.
A
lot like the Hales case. Sounds like what has happened in the Hales case. I can give you one example. There is a hearing I'm going to hold in 2 weeks on an insurance or reinsurance case involving asbestos claims that involves a one-day hearing. On one day, hearing 40 motions for summary judgment and motions to dismiss, and involve approximately 10,000 pages worth of leadings and exhibits. So it's a bit of an undertaking at times.
Yeah, that's one way to put it. I mean, good Lord. Okay. Other questions?
You're Senator Kissel too.
Period. You like how it's just nothing there at first? I like that. Hi, Your Honor. Congratulations. Thank you. Man, why did I have to be like this? And then he has like some actual fucking lines. Well, it would be remiss of me, and I'm going to do it straight on care. Oh, man, I see Manskin's name popping up in here. Well, it'd be remiss of me if I didn't mention the fact that we have been provided with a large amount of papers.
Oh, no, not large. What's the word?
Huge, my bad.
Huge
amount of
huge.
Speaking of lots of paperwork, from the law offices of the Bruce Manskin regarding a particular matter he was not happy about. When is he ever happy about anything?
Yeah, he's never happy about anything. All he does is complain.
Seriously.
All he does is whine.
God, you know, that's the other thing. When we were talking about him not having other, like, any other cases, any other clients, because who has the time to do all of this shit, man? You know?
I know.
I mean, he talks about having a family and these other obligations, but he's like writing 7,000 fucking motions for nothing.
And all these articles,
Yeah.
all these freaking articles, like what, when does he have the time to do all these things he says he does? I don't
When the
know.
what now? Exactly. And I'm just wondering, being sensitive to the fact that there's some things you can comment on and some things you can't comment on, since you're here before us at this time, if you could inform us as to anything that we should know about this matter to the extent that you feel comfortable speaking to us about this.
Well, as you correctly point out, I'm constrained by the Code of Judicial Conduct. There's a rule, 2.10, that prohibits judges from speaking about pending litigation. So I really cannot comment on it to any great degree, particularly as to the merits of the claim, because of the fact that the case, which I did decide, the decision was issued back in October. That case is now up on appeal at the appellate court. So it is a pending matter. So I really can't discuss the merits of it. I can say that after issuing the decision in the case, it was a case that was pending on the complex docket for quite some time. A case a case that I inherited when I took over there, and that it was a court trial, which we heard over, I believe, about 4 days of testimony. I issued a decision based on the applicable law as I understood it. And in fact, I asked the parties for briefs on the matter and solicited briefs from both sides to ensure that the topic and the issues that were involved in the case were thoroughly addressed. The matter was also vetted through the Legal Research Office of the Judicial Branch. So I engaged the assistance of that office in drafting my opinion and issued that opinion based on the facts that I heard and the standards that applied. And obviously, as you indicated, I think Mr. Manskin was not pleased on behalf of his client with the outcome of the case. And I will say that there were requests made for extensions of time for filing the appeal, which I granted in order to preserve their rights for whatever issues they felt that I had either misapplied the law or misconstrued anything. So I've made it clear that in that instance, as with any case, that every litigant's going to get a fair hearing before me and given the opportunity to present whatever argument they want to present to me, and I'll make the decision to the best of my ability, which is exactly what I did in that case. Note that he asked for extensions of time and was granted.
I've never heard of him doing that before.
It's so unusual. So
No,
like him.
man, who would have thought? And you had mentioned, and to be honest, I don't know a lot about this. And after 18 years on this committee, I'm surprised that this hasn't come up before. But the Legal Research Office of the Judicial Branch, what is that? And what do they do for judges?
I love this part because I didn't know about this office either. And this is really, really cool. Well, there is an office. There are legal research interns, etc., legal research clerks, actually, available to the judges who assist with legal issues that may come up. And the judges can't present questions that arise that they may need, or they can present questions that arise that they may need assistance in researching a matter, cases, case law, etc., on a particular topic. And depending on the availability of the number of clerks, which is, as you might guess from budget concerns, if thin, is they are assigned to us and given once a formal request is made, there's a procedure by which it's done. We submit a formal request for assistance, and they then, based on the issue that's presented to them, will assist in the research of that particular issue. My sister, by the way, was a clerk for judges in Maryland, and it is an awesome job. I mean, and when I say awesome, I mean awe-inspiring, because they do all of the research to write the opinions for the judges, and which is exactly what he's describing here.
They're the people who make the judges look smart. Is that what you're telling me?
Well, yes. But interestingly enough, the judges don't always agree with the clerks. They usually do, but they do their own work as well. But they're using the clerks to help them get the law, correct and the citations. It's a very important and scary job, because if you mislead a judge, you're going to get your ass nailed to a wall. I mean, you make a mistake like that and it can make a judge look bad. Think about that.
Oh, yeah. Yeah.
And
Yeah, they
it's
could have
brutal.
huge ramifications too. Yeah.
Right. My sister really loved it, but it was very high stress, right? Very high stress job.
Oh,
But she was
I think
perfect
I'd
for
like
it because she's
that.
very smart. She's very smart, and she never had a problem like that. The judges loved her. Okay, sorry. So Senator Kissel, you may continue.
So earlier today, Representative Carpino had indicated that there was another judge that actually had lost one of the clerks associated with the complex litigation docket, but at least they still had access to legal research individual to assist them with certain matters. In this matter, you availed yourself of a legal research person as well.
Well, yes and no. Typically, the judges on the complex docket, up until recently, did not have we usually were not privy to having the legal research clerks available to us because we had designated court officers. And the sort of custom had been, well, you've got your court officer. The legal research clerks really are more designed to be of the assistance to the short calendar judges, regular trial judges, etc., which is understandable. But after some thought on the issues, and particularly some of the cases that were before not only myself, but some of the other judges in terms of the sheer complexity of them, for example, the St. Francis Hospital cases, which I'm presiding over, it was thought that it would be best to make those research clerks available to us simply because of the sheer volume of work and issues that were before us. And that has been done at this point now.
The short calendar sounds like an insult, by the way. You know, you're on the short calendar, son. You're like, wait a minute.
It's the micro calendar.
To the best of your knowledge, are there any other matters? Yeah, okay. Just a second, my screen locked up for a second there. All right, there we go. That you're aware of. There seemed to be an inordinate amount of concern regarding a decision that you've made in either criminal or civil matter.
Not that I'm aware of.
Okay, he uses jeepers. That's weird. Okay, check this out. Okay. And have you tracked it all in jeepers? I should know this. Jeepers.
I love it when senators use language like this and jeepers.
Oh, gee willy. Yeah.
Gee willikers.
Yeah, that's crazy.
Correct.
Okay, so in the short period of time that you've been handing down decisions, have you lost track at all how you've done an appeal? Or are we just too early in the ball game to find that out?
I can give you a general idea that I've probably had about 40 cases up on appeal. Can I give you numbers on exactly how many were, affirmed and how many on which they were overturned? There would be a couple that I've been overturned on, and the great majority of them I've been affirmed on.
I wonder what the odds are on that typically, like how much should a judge, like if they're a good judge even, they're going to have some overturned.
Well,
no
I would
matter
say
what.
out of 40 cases, you have 2 or 3 overturned is pretty good.
Yeah.
That's because, all judges get overturned at some point for some thing or another.
It's some procedural mess. That's why when we talk about that, again, some people may think that's nitpicking, like when we talk about the Hales case and some of the statements that the judge makes. But if you're trying to run potentially error-free, you really have to watch it. Well,
and as they say, appeals are for losers. You've lost already.
Yeah.
If you're in the appellate court, you've already lost. And if you manage to scrape out a win in the appellate court, it's not necessarily a huge win. Because let's take the Laura Owens case, for example. Let's just say that David Gingras managed to pull an appeal win off some technicality that he was arguing, that Rule 26 bullshit or whatever. That doesn't change anything that happened before in her case, or the findings of that she had no evidence, that she fabricated evidence, that her evidence was that her whole case was brought in bad faith. One error by a judge about something technical does not change what happened in the lower court. Especially on a case like that. So, people like David Gingras who crow about winning stuff on appeal. It's like, so what you're saying is you lose almost all your cases.
You have to win on appeal because you can't.
But you have to win on appeal. Yeah, if you're always in the appeals court, you're a shitty lawyer. Period.
Yeah, I mean that's probably something that a person like he doesn't want to bring up a lot. Okay, so thank you very much.
Thank you.
No, thank you.
Thank you. Thank you. All right. You are Representative Hetherington.
Thank you. Welcome, Judge. I just wanted to, for the record, make it clear you are not related to the members of this committee. Representative John Shaven.
I am not.
Shaven is shaven. Awesome. Okay.
Though he and I might want to have a discussion after the conclusion of the hearing.
Okay. You're not funny. Blah, 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 blah. That's
Not
what it said,
that I
like,
know
okay,
of.
okay.
Yeah, okay.
It's like, your joke didn't land. Okay, thank you and congratulations.
That was her only question. Okay. Representative O'Neill then comes up. Okay, here we go.
Wait, was that a
O'Neill now.
woman?
I guess.
Oh, I should have gone different. My bad. Representative O'Neill. Okay. Thank you. I'm glad Representative Hetherington was able to clear your name with respect to the other shaven.
I'm not so sure which way it works. That's the problem for the representative. So that's actually funny. He may want to clear his name from me.
Exactly. I understand the constraints that you're under with respect to the Chicago title insurance case because it's up on appeal. But I'd like to talk a little bit about some of the other cases that were referred and some of the materials that were sent to us. One of them is the case of Anna Pister versus Nationwide Mutual. What a terrible name.
What a name.
Mutual Insurance. And there's another one. I think RD something.
Pissed her off?
Exactly. It's like, you should know. You should meet her brother. Yeah.
Pissed her. I hardly knew her.
Oh,
terrible.
Terrible name.
Megan, that's terrible. You should be ashamed of yourself, Megan. That was a terrible joke. All right. RT Vanderbilt, I believe.
Vanderbilt? Are those cases? Are you able to talk about it all?
The RT Vanderbilt case is a pending case.
Okay.
So again, I'd have similar concerns. The Pister case is again.
What a name, man!
The Pister case. At least it's not Fister. The Pister case
no.
is a case that, as far as I know, was concluded. I don't believe it was taken on appeal or anything like that.
That would be a terrible name, by the way.
Awful.
Okay, let's see. You didn't cite were they complex litigation matters? Let me ask you that.
The Vanderbilt case is currently a pending complex litigation case.
And what about the Pister?
The Pister case was a case on regular trial docket that I heard while I was assigned to Danbury.
It sounds like a low rent toilet. The Pister. It sounds like something you screw in the wall, like a little urinal.
Aaron Wild, thank you for this. That wasn't a bad joke. I'm still laughing. Okay, good. And I'm glad. That was the idea. By the way,
there are 2,600 of you. Congrats for being here. Tell other people that we are live on Megan's channel since she was Latosaurus,
Latosaurus Rex.
Yes, very much Latosaurus. So, and also, make sure if you like this content to support with Yo breadsticks or Yo sound clips, however you would like to. Make it fun.
But speaking of sound clip, we've got super tips. We've got some super tips to go over. So let's play a couple of those so you know how they work. Bill Jerzemba, thanks for the 5.
There's a menthol hamster head at the foot of my bed.
And SF, thanks for the 5.
Megan is as late as I am after a first date.
Oh no, that was good.
That was so good. Skipper Trucking, thanks for the 5.
The only woman on the planet late more than me is that damn Megan Fox.
And Maho, thanks for the 5.
Hey Megan, 40 minutes to late is for a lady just in time.
I love hearing my dad's voice on here. I swear to God. DTG 1032. Thanks for the 5.
You and the JFC cult can focus on Florida on May 29th. Nothing to see here.
Take the WTH ecosystem to Arizona on May 29th. You can take Tree Stranger with you.
Oh, shit. Oh, my God.
And Paul C sent a super tip text, which says, here's some flocking cash for breadsticks. Well, I appreciate that, Paul. And also DTG sent another 5.
You could cover both cases on May 29th. I could be a double header, so to speak. You could cover both cases on May 29th.
Why is it repeating
itself? I could
itself?
be a double header,
Stop.
so to speak.
Okay,
It's a
there we
double
go.
header, so to speak.
Maybe a double header, so to speak. Yes. Oh, so funny. I love super tips. Super tips are fun. And if you want to check it out, it is pinned to the top of the chat. You just follow the link and you can send an AI voiced text to me. And you know what's fun about it? These are not real people. This is just AI for satire and parody. No one wants you to believe that these are actual real people. We're just having fun with robots. And so everybody out there who's concerned about voices, take a joke. Mine's in there. If you want to make me say something really outrageous, you can do it. And Tugs is going to be in there soon too, because he said I could do it. So
Oh no. What have I
But
done?
I've got
No,
some.
I'm
I've
sure.
got more voices on the way. There's like right now, it's just me, Nick Ricada, Florida woman, pregnancy faker, and Darrell Brooks, I think. And there's going to be, but we have on the way, Douche Canoe Esquire, Judge Bev Canoni, which Auntie Bev should be hilarious. And Legal Vices will be in there as well. So I've got a few pending, and then I'm going to be adding Judge DeThomasis at some point because he's so funny. Judge Grudge will be in there because he's got a great voice. All right. Let's see. Where are we at? We are at O'Neill. Representative O'Neill.
The okay.
Oh, wait.
Guess the first
Did it?
question
Yeah,
is?
that's
Is
it.
that right?
Yep,
Okay.
that's
I
where we
guess the
are.
first question is because part of what Attorney Manskin's concerns was conveyed to me is a concern about how the case got transferred to complex litigation docket in the first place, the Chicago case. And I'm just wondering, how do cases get put on the complex litigation docket in the absence of the party's request that it be put there? Is there how's the process work?
I can give you hopefully some overview to the best of my information and knowledge. Generally speaking, complex cases get there because the parties, as you point out, have either asked for them to come or they can be sent at the request of the administrative judge of a particular district. To give you an example, there was a case when I was in Litchfield. It's a bit ironic that when I was there was a medical malpractice case. There was thought it would take probably, when we asked the attorneys, it would probably take between 3, 4, maybe even 5 weeks of testimony and jury selection. Well, the courthouse in Litchfield, as you're probably aware, is pretty small. And in effect, there are really only 2 courtrooms up there. And if we were to do a medical malpractice case, this would take 4 to 5 weeks. That would effectively shut down half of the ability for the court to address all sorts of other matters, whether they be family matters, criminal matters, whatever. And so at my suggestion, I approached the administrative judge and said, this is a case that probably would benefit from going to the complex litigation docket because part of it is not, it's complex, not just in the substance or nature of the case, but the ability of that particular facility to even do it. And so I approached the administrative judge and he agreed that it should be referred to complex. And it was, and I say it was ironic because once I got to complex, what was assigned to me was the very case that I had talked about assigning from Litchfield to the complex docket. So there are more than one ways it can come to complex.
So a lot of times, that's interesting. So it might just be the inability to handle
The courtroom. Yeah, the
that's
size of the
fascinating.
courthouse. It
Huh.
is, but it makes sense. You don't
Yeah,
want
it
to
does.
you don't want to cripple a courthouse that only has 2 courtrooms for 5
No,
weeks.
that makes sense. But I really wasn't thinking about the size of the courthouse itself as part of
Mhm.
that.
I wouldn't have
That's-
thought of that either. I find this transcript
Yeah,
entirely
that's actually
totally
that's actually
fascinating.
fascinating. It's
Yeah.
nerdy, fucking fascinating, but I like
I know
it.
it's
I think
nerdy,
good.
but I was listening to I had it on Speechify in the car and I was listening to other judges being interviewed and
Mhm.
there was some seriously interesting stuff in here, like about cases of SA offenders that one judge let go and there was an outcry about it. And I was like, ooh, I need to look into this story.
Yeah, but sometimes Bruce really triggers some really fascinating commentary, like this, for example. Let me show you this real fast. We don't even have to really
Sure.
just check this out. I mean, it's
All right, let me
look at this. Look at this
switch.
really complex speech that he gives. You're an imbecile. No, it's very nice. Let's see. Oh, what's he have to say about these people's posts? Oh, another idiotic post from an idiot. Wow, that's very poetic. Idiotic post from an idiot. Very.
Oh God.
Man, the poetry that flows.
Good
He
Lord.
was really
this
riled
guy.
up the other day for some reason.
Ugh.
Okay.
All
So if it's not being recommended by the parties, then presumably it's being recommended by the judge who's familiar with the case enough to know how long and how big and how complicated it's liable to be.
Right. And then the request actually would come from the administrative judge and be made to the chief administrative judge for civil matters. And it is the chief administrative judge's decision whether or not it should go on to complex.
Right. that actually reminds me of Randy, you know. Right.
Okay.
Right. Yeah.
Uh-huh.
Okay. And then the request actually
Wait, no, that's the
become
next
oh,
one.
whoops, my bad, my bad.
You're at
Yeah,
okay.
okay. And what kind of? I mean, you mentioned a 5 or 6 week long medical malpractice case. Then you suggested, over the complex litigation. What is the typical length, assuming that's an indicator of complexity? The length of time it takes could be an indicator of how slow the lawyers talk. I suppose the witness slow to answer, how slow they talk.
God, senators are so
make it.
stupid.
I'm like, I
No,
make
it's not
this
about
very
the-
complex.
It is not about how slow they talk.
They're like, oh
Senator
shit,
O'Neill. This is like the equivalent of that one senator who was like, well, what if Guam capsizes? It's like, so these cases take long because they talk slow.
And that's so funny
No.
though. What if Guam capsizes? That's amazing. Ugh, there are some dumb people out there, man.
And
You
a lot
know?
of them are senators, unfortunately.
Yeah, that's an unfortunate thing. Like a lot of them do represent us. That is the scariest part of it all.
Yeah.
Okay.
American senators have a large representation of idiots, unfortunately.
Well, I guess they are supposed to be representative of the people that that they do represent. So
There's a reason why there's that famous saying, I would rather trust the first 400 people in the phone book to make decisions for us
true.
than in Congress.
That's true.
It's true.
Okay, but assuming there is that's something that's willing to do with the complexity of the case, it's some indicator. What's the typical length of a case that's in uncomplex litigation?
I would say, and I give him credit for not mentioning how stupid the senator is for asking him about slow talkers. I would say that I don't think I can give you a specific figure, but it's not unusual that if you were to look on, for example, my docket or some of the other dockets that the judges I sit with in Waterbury, that typically we have to block out, basically, I would say on average, maybe 2 months worth of time between jury selection and presentation of evidence for a particular case.
That would
And so
have
one
been
of the
funny if he would have taken a shot at him though, and it'd have been like, "What makes something complex? Talking to you idiot." You know?
And so one of the issues in complex is trying to fit them all in, because obviously when you're measuring out the significant blocks of time, things get pushed out pretty far. So part of the challenge in complex is trying to gauge a balance without scheduling cases so they're not put out so far that they become problematic. The litigants or the attorneys may be saying, well, geez, it came to complex on the theory that we'd be able to get to it. We have a designated docket, and yet now we're being pushed out farther than we might have had on a regular docket, in the regular courthouse. So I try to be very sensitive to that. That entails often we will double book cases. We will even triple book cases, because we have found, I think statistically, that the cases in the complex docket settle at about the same rate as regular cases. So most cases do settle. So we have been able to go through that practice, have it be successful in addressing the time frames the people are concerned with. And it's also been made very clear by the chief administrative judge for civil matters that if we do have matters that are, say, multiple bookings and they both are ready for trial, well, there will be a judge made available so that the matter doesn't get kicked out any further.
Good Lord, that's a lot. He does give some good lengthy answers. But
Yes.
Man, they are. Okay. And with respect to one case that I guess it's the Pister case, was not a complex case.
No, it was not.
Do you recollect how long that case took to try?
That wasn't even a trial. That was a summary judgment motion on a declaratory judgment action for determine whether insurance coverage should be in place or not.
Okay, and the coming back to attorney Manskin, and have you had other matters where he's appeared before you as an attorney that you can recollect?
No, that was the only matter.
Nay, nay, nay.
Nay, nay, nay. Thank God.
Okay. Indeed. And what about the other attorney on the other side in that case? Do you recollect whether someone that has appeared before you previously?
I believe that would have been Attorney O'Hanlon from, I believe, Robinson and Cole. I think that was the first matter he was before me on. I believe he's before me, I know he's before me on another matter. I'm just trying to remember whether that preceded this matter or not. I don't think it did. I think that the other matter came up subsequent, so this would have been the first matter that he was before me on also.
And when you've been doing this complex litigation docket in Waterbury for the last couple of years?
Almost 2 years now.
And I'm sorry, but I don't remember exactly. But prior to Waterbury assignment, were you in Danbury?
I was in Litchfield for a brief period of time and then was pulled out sort of midterm to help fill the position vacated by Justice Evely.
Okay, all righty. Hey, we got a righty, by the way.
All righty.
All righty.
And a Jeeper. We got an all righty and a Jeepers.
Yeah, man. We should have a fucking card for this today. You know? I swear, I might have to leave if we get a dog will hunt or something. Like that.
Don't even say that. It's going to happen now. That dog
that
will
would be
hunt.
amazing.
Oh, God.
I guess I don't have any more questions at this point. Thank you.
Thank you.
If you'd addressed this, I apologize, but I was just curious, following up on Representative O'Neill's line of questioning. Is the consent of all parties required in order for a case to go to complex litigation?
I don't know. I mean, technically, I would say probably no, because again, the administrative judge can make the request directly to the chief administrative judge for civil matters. Though I will tell you as a practical matter, for example, the situation that I gave you with the medical malpractice case, it wouldn't be done without speaking to the parties or the litigants first, or the attorneys, I should say. Senator? Senator.
I'm reading. Give me a second. Isn't generally the case that the parties might refer a referral? Good Lord, refer
What?
a referral. Yeah, I thought I was reading
Okay.
that wrong. To the complex litigation docket.
Yes, the parties can make an application. Either side can.
Is it something that, given the nature of the case, of the complexity of the case, that it's likely that they would prefer to be there?
I think generally speaking, I think there are a number of attorneys who feel that there's a great advantage in going to the complex docket because of the fact that they will have one judge paying attention to the case from start to finish. And in that sense, they know that the judge will have some familiarity with the case, won't have to re-explain it sort of again, or the background of the case if it comes up before another judge, say, as it might on a regular docket.
Thank you.
All right, now we're going to go
Representative
down
Smith.
here to Smith.
All right. You know, I'm not sure what you did during your term in Danbury, but I must tell you that I receive a lot of complimentary letters. Ooh, man. There's a lot of back patting in this, isn't there? From the Danbury Bar, of which I'm a member on your behalf. So you must have done something well in terms of litigants and the lawyers in Danbury section of the state of Connecticut. So I commend you on that.
Thank you.
And I had the great opportunity to try to talk in front of you as well. It's not an appeal, so we can talk about it. It was involving a vertical expansion of non-confirming use, which are always fun to talk about and litigate.
A personal favorite of mine, yes.
Oh, mine too. It sounds like a blast.
Sounds like a great time.
It does, man. It sounds like a drinking game. They just need to make one.
Vertical expansion of a non-conforming use. What are we talking about?
I have no idea. But it's the first time I had appeared before you. And again, I must commend you on your diligence and research in the law, being familiar with the law. Whether you had been prior to that or not, I don't know. But you delved into the file in it because it was a very unique issue in my mind involving, the regulations for a particular town versus the cases that had been done before that. So you were well attuned with the law, and I just wanted to let you know that as far as I'm concerned, as far as the members of the Danbury Bar are concerned, you're well
We're gonna lick
respected.
your ass.
Exactly. You're the sexiest,
Slurp,
finest
slurp.
man. Man. Now, if we could put you on an issue, a Playboy, we'd buy it all up. Okay. Yeah, that's blah, blah, blah.
All right. Other questions. We have Taborsak. What does he say? What?
Nice to see you today.
He's also kissing ass. He's
Yeah.
kissing ass.
You're
Smooch,
so
smooch.
beautiful. Love
Good afternoon. Okay, this is Representative Fox. Okay, this is getting back to Manskin, I think. I think we're getting back to Manskin. Number of attorneys I respect greatly, blah, blah, blah. Would be helpful. Perception of fairness. Okay, so this is what he's going to say about, oh, Jesus. Look at
Good
this answer.
God.
Good grief. Certainly, I think to underscore some of the positive remarks is that my goal each and every day that I work, go out on the bench, is to understand the importance with which the people who are before me have an issue in their lives that is paramount at that moment in time. The people that are before me are there because there's something going on in their lives, that something big has happened. And I understand that. Those individuals who come to court are looking for the court to be even-handed, to be fair, and probably more important than anything else is to listen to them. And it's been my experience, whether it be on the criminal bench or as a civil judge, to give everybody an opportunity to be heard, to treat them with respect, to treat them fairly, there is nobody that's going to leave my courtroom who is going to say, I did not get a chance to present my position to the judge and to be fully heard on whatever issue that may be before me. The reason that that's paramount is not just to those litigants, but to the judicial system as a whole. If the participants in the system walk away feeling somehow or another that, there are things not going on here that are fair, that starts to tear apart at the fabric of society. It's that level of, I agree with this 100%. It's that level of belief that a litigant can come in and say, I'm going to get a fair hearing or an opportunity to be heard that keeps people believing in the judicial system. And the strength of the judicial system is important because it's really what keeps the fabric of society woven together. Amen. Definitely, 100%. If the citizens of the state don't have a belief that their judiciary can fairly handle matters that are before it, then you start to bleed into chaos and anarchy. Yep. So it is paramount to me that I treat everybody fairly, that any power I have as a judge be used judiciously, because that is the only way that we can instill confidence, not just in the litigants that are before us, but to the citizenry as a whole. So I assure you that each and every day I walk out on that bench, that is my overriding objection. All right, here's a follow-up from Representative Fox.
Thank you, sir. And through Mr. Chair, I have a follow-up question. You often hear of litigants who appear before a judge and they'll give different context in criminal court where a judge may have prosecutorial background, a defense background, criminal defense background. Attorneys who appear before that judge might feel that the background is going to influence them in some way. And I know that I have seen that sometimes it's the absolute opposite of what people might expect. Yeah, I actually don't believe that, to be honest. I believe that, if they have a prosecutorial background, oftentimes they do lean toward that,
Yeah.
I've seen that,
I've seen it. Yeah, there's lots of judges most judges are pro-prosecution.
Mm-hmm. But I've also heard the same thing in the civil context if somebody comes from big plaintiff's personal injury firm, for example, people might think they have a tendency to lean toward that direction or the defense background. And it's important I can recognize, given your comments to the last question, that you understand is important that not come into play, in a courtroom. So I appreciate it, blah, blah, blah. I'm glad you said
It's
that,
interesting.
baby.
I listened to a bunch of other interviews before this. I didn't read this whole one.
Mhm.
And they spent far more time on Judge Shaben than anybody else. And I know it's because Manskin papered their offices
Oh,
about
yeah.
all of his grievances about this poor man. And I mean, it's incredible how much longer they are grilling him than anybody else.
Yes, they
So-
wanted to make it look like they were doing their due diligence because, I mean,
Right.
he's
Because
crazy,
Manskin
man.
causes all kinds of, upset. And it's crazy. So the judge replies, one thing, and I, in fact, have been in the past designated as a mentor to newly appointed judges. And one of the things I've stressed, not only to myself, but to them, to remember that as a judge, everybody in that room, in the courtroom, has an interest in what's going on. And when I say an interest, they're looking at things from a certain particular way. The judge is the only person in that room who is and must remain neutral. And I keep that in mind every time I go out. Right. Then Holder Winfield has it. This is the first judge that they all have questions for.
Yeah. Yeah. I mean, it's not typical that they grill you like this. I recognize, I'm looking at question 21. The question about how you filed, have you had a complaint filed against you, rather? And I recognize it's only one complaint that we're seeing. One complaint, I see.
Mhm.
But the reason I'm asking you about it is because of your comment about the way people walk away from your courtroom. And it seems to me that whether there was a basis here or not, it seems to me that if that person filed a complaint alleging that you were biased, that at least this individual has walked away from your class, your courtroom, your class. Not feeling as though you're really listening. Well, it is a courtroom and not a class. That
it's
is
not a
kind of
classroom.
that's kind of a dipshit way of it. It shows you what he was
I
saying
told you that
there.
representatives and senators aren't very smart.
And so I wonder if you remember that, and if you could talk to me a little bit about why it doesn't really go against what you've been saying here today.
The particular litigant involved is one who has a myriad number of cases in the past, included foreclosure matters that I believe are concluded. There may be some that are still pending. If there are, I don't know which ones. It involved a piece of property that this particular litigant had, and there were a series of rulings by me in that case and related cases that were adverse to her. And she felt that because I had ruled against her, that in essence constituted bias against her. And these were cases, by the way, that this particular litigant had pushed through the court system and had elongated to the point that some of the ones that I was dealing with were 10 or more years old. Okay. And each time that she received an adverse ruling, she would find some other way to manifest some sort of issue that then needed to be addressed, which would result in another adverse ruling. Doesn't this sound familiar? And by piling them up, determined that, well, if there are many adverse rulings, there must be bias on the part of the judge. So I can tell you again, only that each time every issue came up, the ones that I handled, I applied the law, whatever the standard of law may have applied to the particular issue that is before me. I listened to the parties. I had a hearing, and based upon whatever material that was before me, I entered a decision based on what I thought the law required. Now, Mr. Smith. Mr. Smith goes to Connecticut.
Yes, that's what I was thinking there. He sounds the right person to ask some questions.
Oh, never
right,
believe a representative who says, I'll be quick. Look at his idea of quick.
Yeah, I'll be quick 4 years from now.
8 years later.
I'll be quick, but I just wanted to relay to the committee my personal experience before Judge Shaben, in the sense that it was 3 lawyers involved in the courtroom. It was an argument to the court, so it wasn't a jury or parties were all there. And what I was most impressed by was the way he handled the court. Is that what all this is again? Is this more?
Is this just ass kissing?
That first paragraph, yes, for sure.
In this
second paragraph, yes.
Yeah, second paragraph, maybe not. I don't know.
Yeah, it is. It is.
Oh, it is?
Mm-hmm.
All right, so
Yeah,
he's just giving his personal experience that Judge Shaben
He's
was
like,
very
I
fair.
love you. You do
I
great.
love you. I'm gonna kiss your
I think
ass.
it's basically
more.
having to be defended. That's what it is, because somebody
Right.
has papered complaints about this judge. Wonder.
Thousands of documents that,
So here's O'Neill. Okay. I had one or two more that I wanted to ask, and I forgot and finally found them. When a matter is referred to complex litigation docket, apparently there's an order saying such, and apparent most of the time orders indicate that there's 15-day period within which to object. In the absence of an order stating that, can a party object to the matter being placed in the complex litigation docket? Is that a rule that they can just evoke, even though the notice doesn't say anything about it?
I do not know that there is such a rule, Representative O'Neill. I'm not sure is what I'm saying.
Okay. If somebody does object, if you they come
Manskin, for instance.
Yes, indeed. They come to you. A matter has come to you, and they did object. How often would you, or can you remember ever sending a matter back and saying, no, this is inappropriate for complex litigation?
I'm not sure of your question. You're saying as before my assignment to a complex?
No, excluding in complex. Have you ever had an occasion to say, nah, let's send it back?
It's not my decision. Once it's assigned to me, it's assigned to me.
Indeed, it's about trial assignment. Lord.
Oh God.
Okay, so an objection wouldn't be addressed to the trial judge. It would be
the
addressed
trail
to
judge.
The
Someone wrote trail
judge.
judge.
Get on the Oregon Trail. You've been taken out by malaria. Oh my God. I haven't
You've
played
been
that
taken
game
out
forever.
by sheer boredom from these representatives.
I need to freaking play that game with my kids. Show it to them, you know.
Oh God, that game is so fun. You know they have free versions of it online. You can play.
Oh yeah, I need to show it to them now. But
fun.
they'll never know the feeling of that actually being the only cool computer game back. You know what I mean? That schools could play or anything.
And it was so fun. God, we loved it.
Oh yeah. You'd see how many times you could die, so you could put up some cool, like horrible sounding tombstones.
Right.
You know, Mr. Pee-Pee was here. You know what? Oh my God. Okay. Which
you're here.
The trail judge. Oh yeah. Okay. And did you ever have any kind of contact with attorney Manskin now when you were in private practice?
No.
Thank you. All right.
Thank you, Senator. Okay, then we have Coleman, and this is a new judge. Okay, so we're at the end of the judge there, but it sounds like Bruce may have testified at this thing. So let's see if we can.
He actually has a statement. I saw it lower on.
It's right here. Yeah. Oh my God. All right.
My goodness.
Well, clearly you're going to be Manskin.
Good afternoon. Oh man, let me Chairman Fox. That's why he hates you, by the way. That's why he hates you, because of this hearing. It's in there. Fox, yoga.
Oh,
I understand it all now.
Yeah, maybe that's it.
Chairman Coleman and members of the Judiciary Committee, particularly Representative James Albus, has been very generous with his time. Oh my God, can you imagine what that means? Can you imagine how much time this guy has?
Oh.
God, you know, he's sold a bunch of.
He's probably one of the two people who voted against the judge.
Oh, you know it is, because he's like, you know, you were kind enough to listen to my concerns over the phone. Oh my God, that would be even worse. Oh my God, you know, I've only seen a few people ever beg for folks to call them. There was, I'm not going to bring up that person's name, actually. I'm not going to bring them up. You said not to bring them up, so I'm not going to bring them up. You know who I'm talking about there.
Yes.
But also, there was one other attorney. You know, there was a certain attorney, too, that when he was getting desperate, he would say, well, people can call, blah, blah, blah. But this guy right here, this guy, he begs for people to call his office. It's crazy. But I thank you for hearing my testimony today. And I learned that although in 2 years as a law clerk for the justices of Massachusetts Superior Court, after graduating, because I'm so great, from Boston University School of Law in 1996, I drafted about 100 decisions for the dozen or so judges. Sorry, that's my marijuana kicking in. 24 or so judges. And it has never once occurred to me not to address the losing side's arguments or legal authorities. Oh, God, that's so whiny. So he's like, we're losing, but you didn't address ours. This is the same argument that he put in with Gainesville to Gainesville. It's the same whiny thing that he said. You know, you didn't listen to me, Judge.
Yeah,
Obviously,
you didn't address
smarter.
our losing arguments.
I'm so smart, Judge. If you would have just listened, you'd have been down on your knees, you know? Oh my God. You'd have been paying me like we were on the street corner again, just like law school. No, that didn't happen. Give me a second. I got a drink.
Here, we have a couple of super tips that came in that are hilarious. Let's take a second and do those. Rosilla's Realm, thanks for the 5.
Residents of Otter Creek, Florida, be on the lookout for a cross-eyed burglar. If you see him peeking in your window, kindly warn the neighbors next door.
Okay.
No.
Joan Slafani, thanks for the 10.
Just because I listen to this stream doesn't make me a stalker.
And Snarkasm, thanks for the 5.
I upgraded my blue bucket to the new Peaster 5000.
The Pister 5000!
Bucket to the new Peaster 5000.
Oh God, is that funny?
That sounds so good.
Oh my God, so funny. All right. Well, let me pull us both back up here. Okay.
Let's see. All right, Megalodonus interrupting me. Don't you know who I am? Well, we actually needed that 15-minute break. Yeah, needed that 15-minute break, though. So, our own Connecticut practice book, section 61, 61,
69.
States very clearly that in rendering judgments in trial to the court, the judiciary authority decisions shall encompass its conclusions as to each claim of law raised the parties and actual basis therefore. God, he sounds whiny. It just reads whiny to me. Since becoming a solo practitioner in 2004. It's 2012, by the way, if you don't know that, from the header at the top. In Connecticut time, in 2004 in Connecticut time? What does that mean?
Is time different in Connecticut? What?
I don't set my watch to Central Standard, Megan. I set it to Connecticut time.
Connecticut time. Mm-hmm.
My calendar's for that. And again, I have the indescribably frustrating experience of expending numerous hours, months, and even years on a legal case, only to have a decision in the end that failed to apply the law or sometimes even acknowledge the facts. I'm always right. I'm going to skip over a couple of anecdotes. Thank God we didn't get those. In my written prepared comments to save time and to tell you that these experiences have contributed to my decision to come here today to talk about Judge Daniel Shavin. As explained in the letter that I emailed and mailed to each of you, there you go. That's your plastering,
Yeah.
Which is posted on the committee's website, public hearing testimony page. I am my co-counsel who is here with me today. Look, there's actually a human being that does like to be around me. And our clients, an LLC formed to develop senior and assisted housing in the land of Bristol, received a decision. I don't know. I'm just oh man. I'm imagining being involved in housing. Lord. Received a
Oh.
decision from Judge Shaven last August after 5 years of litigation, in which the judge ignored the law for construing insurance policies and the insurance policy provisions that we've relied on all these years. Only a month before Judge Shaven wrote a decision in another wait, I'm having another smoke break. Just a second. Okay.
Need the devil's lettuce? No, hold on. While you smoke the devil's lettuce, we might as well play another super chat.
Gotta
I
pick some
upgraded the
cabbage.
Blue Bucket to the Peaster 5000 Deluxe model. I
Oh my
upgraded the
God.
Blue Bucket to the Peaster 5000 Deluxe model.
All right.
Oh.
Are you sufficiently THC'd up, counsel?
I think I haven't got my Waco, my Bacos on. Let's do it.
Waco, my Baco.
Insurance case called R.T. Vanderbilt, in which he fully acknowledged and applied the same controlling legal standard. In our case, he also ignored a series of Connecticut Supreme Court decisions and a statute which was directly relevant to the dispositive issues on which he decided against us. After
Here's two. I'm sure, by the way, that they did not apply. They were not relevant and they did not apply. I am absolutely sure. Without even seeing the docket, without seeing the motions, I can pretty much say they were not relevant. Spoiler. Okay.
Wait, he had 2 other law firms. After 2 other law firms appeared for the little money I could afford myself, afford to pay them. Judge Shaven denied their motion for a re-argument without a hearing or written decision or any acknowledgement of even his own prior decisions, in which he applied the legal standard he ignored in our case. Oh my God. One of those firms is now handling the appeal for basically nothing. I wonder if it's his
Basically
version of
nothing?
nothing.
Basically nothing.
What does
which
that
means
mean?
Not nothing.
Yeah, so I could be like, $50 million, basically nothing. You'd be like, wait, that's not nothing. Well, it's basically nothing.
It's basically nothing.
I mean, what does that mean?
It doesn't mean anything. That's just
It has
another
no
way
meaning.
of him. Just as another way of him trying to pretend like they do things for free and they don't.
Just as Attorney Sullivan took on the trial as my co-counsel for no money. I wonder if that was, again, for some contingency based on insurance, or if he was suckered into it. On the insurance policy language and the legal standard for interpreting it, never imagining these would be ignored by the trial judge. Never. Members of the committee, the late, great Robert Satter, defined judicial integrity as, quote, doing the job of judging honestly, making findings of fact on the basis of all the evidence and not ignoring evidence that runs counter to the judge's own concepts of the case. Oh, I'm so important. It does sound fucking really self-important.
Yes.
Integrity. It also means a judge applying the law rigorously and rendering a decision required by the application of the clear statute, controlling precedent, even when he does not like it. A judge who lacks that kind of intellectual integrity, let it say, is a disaster on the bench. Close quote.
When did the quote open? Where was the open quotes? Never mind.
Oh my God. He's just like randomly closing
quotes. Yes, close quote. I and my client. Close quote.
It's so amazing. I hope you will consider postponing your vote on Judge Shaven today. I think you will find members of the bar willing to talk to you, perhaps even coming out of the woodwork. They're going to sprout out little people in the walls, baby. To do so, if you take some time in light of what has been brought to your attention. And if you ask other experienced litigators, I predict you will not find one who can show another documented example of what I've shown you. God, this is the same shit he whined about with the bar. This is the exact same whining. So when he loses, he's a very sore loser.
Oh, yeah. Huge sore loser. And he is constantly making the same arguments over and over again. And when he's told no, he just continues to make them. It's quite amazing. Like, he cannot accept no for an answer ever.
Now, what amazes me in this stuff, again, you can target judges, you can do all this shit like most people would. I mean, just it blows your mind that would go on. You'd think, no way are people out there doing, oh yeah, oh yeah, apparently quite a bit of it. So, oh God, crazy stuff, man. You will never find one. I predict you'll never find one, a judge applying law in one written decision and then ignoring the same controlling law in another decision issued shortly thereafter, despite it having been cited and relied on by the party he ruled against. A journalist, Mariah something, observed in her book, The Devil's Knot, about he's quoting the West Memphis 3.
Uh-huh.
What the fuck does this have to do with this?
I don't know.
About the railroading of innocent teenagers in the famous West Memphis 3 case. Quote, holding people accountable or not is the privilege of those in authority. I would add to that it is the duty of those in authority to hold people accountable. He threw the West Memphis 3 in that. What a fucking schmuck, man. In Connecticut, these constitutional reappointment process is only accountability for judges who refuse to apply the law fairly and impartially. Today should not be the end of your integrity. I'm sorry, inquiry. My bad, man. My brain is just like, how many more pages?
I've given you a lot to read. I'm sorry.
He's like, Jesus wept. Inquiry into Judge Shaven's qualifications for reappointment for 8 more years. It should be the beginning, because a whole subprofession of lawyers, those who invest their time in cases for parties without financial resources.
Oh, shut your face. Shut your dumb lying face. Oh,
yeah, he's playing the pro bono again. That really does make me mad when he plays the pro bono.
Yeah, because he's lying.
Well, I mean, are you allowed to lie like that? You should, I mean, again, is that not a weird little thing we call perjury yourself?
Yes, he's under oath here. This is you take an oath to tell the truth and nothing but the truth in front of these committees.
I said nothing like the truth. That's what I swore to.
Maverick
the truth,
says,
nothing like the
next, Megan will make Tug read War and Peace.
I'm going to be like, it was the best of times. Read it as Bruce. It was the worst of times.
Chapter 1, I was born.
Oh, no. Okay, resources are at risk who cannot rely on the judge to apply the law. And when these lawyers disappear, so does access to the court for people who need them. Oh my God, I ask you to vote to postpone the vote on Judge Shaven's reappointment today. Thank you.
Thank you. Are there questions is it Attorney Manskin?
He answered yes.
Are there any questions?
Yes, again.
For Attorney Manskin, Senator Kissel? Thank you very much, Mr. Chairman.
He said, yes, Senator.
Attorney Manskin stayed right within the 3 minutes. That's great. Also provided us with plenty of written documentation. The dilemma that I have is that despite the documentation that you've provided us with, that my standard for a judge is not that they're perfect, because we're all mortal. No one is perfect, and that's why we have an appellate process. Now, I read not in your written statement now, but in the cover letter to the documents. I mean, you do raise valid points regarding appeals are expensive. Not everybody has that. And so it may be a remedy that's available, but not realistic. If I could just take a step back, because obviously you feel very passionately about this. And I made inquiries of Judge Shaven, and I thought his answers seemed appropriate. Was there anything in how you or your client was treated by Judge Shaven that got this whole thing off on the wrong foot? Did he exercise a lack of appropriate judicial demeanor during the proceedings?
Respectfully, Senator, I believe so. Of course. He's like, oh my God, I was wrong.
Right.
Oh my God. The very first thing, I mean, it's a long history to this case, but by the time we landed in Judge Shaven's court, Waterbury Complex litigation document, it was summer of 2010. It was a very hot summer that year.
I knew you were going to go there. The dogs and cats were sticking to the sidewalks.
Oh my God. I had to peel my co-counsel off of it, in fact, so we can get into this case.
I once ran after an ice cream truck that didn't stop outside of the courthouse.
The ice cream truck melted. It was so hot. Oh my God.
I was forever damaged by the rejection of the ice cream man.
I could actually see him suing them over it. You'll stop or I'll sue. Screw those kids. Now the case has been filed March 2007 by the insurance company preemptively as a declaration action. Whereas we would have sued for damages. We had to be a defendant. The counterclaimant. That sounds like, again, something else that he pulls in this case.
Yeah.
He's like, I'd sue, but I can't. And when it got to this courtroom in 2010, it had already been postponed from trial from 2008, 2009 at the request of the opposing counsel, and then transferred out of the blue to complex litigation docket without any opportunity to object, omitted from our office. Finally, when we oh no, not the weed again.
Oh no, not the wee-wees. He went wee all the way home.
Wee all the way to the back, so you can spark it up. Oh, by the way, there was a quote on him like that. He was like, pot smokers aren't addicts or something like that. I'll have to find it. We got assigned to the Waterbury, and Judge Shaven was reassigned to that docket that take over Judge Evelyn. The first time we met Judge Shaven in his chambers, we had filed a request for an earlier trial date because by that time it had been scheduled for 2012. Our opponent filed a lengthy opposition to our request for an earlier trial, notwithstanding that the case had already been postponed. 7, 8, 9, 2012. We're asking it to be moved up. In response to their written opposition to our request for an earlier trial date, they put a lot of self-serving history of the litigation. So I retorted with a reply brief. I'm just so fair in my retorts too. Probably called them all kinds of names. In which I pointed out a number of what I characterized as violations of my opponent's duty of candor.
He accused them of fraud on the court. Yeah. He accused the opponents of fraud. That always goes over well. Mm-hmm.
Yeah.
False
that's what he does
statements.
to everybody.
Yep.
So apparently he does this to everybody by making certain false statements, because everyone lies but me. Come on.
Right.
And writing in the court about material facts in the case with the intention of influencing judges who are presiding over the issue. And Judge Shaven, the very first time I ever met him in my life, within his chambers with opposing counsel, threatened me from
He
dropping
excoriated me.
Whoa, man!
Doesn't this sound like Judge Blythe though? What happened in the chambers?
Let me copy that. I need
Holy crap! He excoriated me,
so
folks.
It's all over it.
You have to hear the definition of the word excoriate, because that is more than he chastised me. It means to censure scathingly, to wear off the skin or abrade. Boy, does he use
kind of stuff.
harsh
Again,
words.
When you're talking about the history, man, this is what kills me in the federal trial that we're seeing now. You have other judges that have been like, yo, look at the way you're comporting yourself. It's because of him attacking the opposition. So that's what he does. He does it all the time. For this judge to grant him a pass on that pretty much is ridiculous. I mean, he has made a career of doing this.
Yeah,
kind
he's made a
of shitty
career out
stuff.
of it. This is why we're going over this. This is why it's important. This is not meaningless, chat. I just saw someone being like, none of this means anything. No, it does. This is a pattern of behavior. This is absolutely a pattern of behavior. And we are proving that Bruce is the one who's wrong here. He's the one who's constantly finding himself getting excoriated by judges, being sanctioned, having all these negative consequences for the things that he has done in courtrooms. So I'm just letting you know, I find this to be extremely
Well, and it's by his admission. These are his words, though. He's saying, he did this to me. So, I mean, you can imagine. He listed 5 or 6 page numbers for my filings, which was admittedly a bit overlong, and claimed and said to me, I think Mr. Manskin are unethical. He called him unethical for having raised these issues in the filing and had nothing to say about any of the specific particular false statements that I had. Not just, don't take my word for it. I provided documents, as you can see, and all that happened was I was yelling at. I was yelled at. He yelled it, so he yelled at him too.
Mm-hmm.
This is yet another time. So we've heard this twice, Bruce whining yet again about another judge that yelled at him.
But the judge was yelling at him for the same things, for violating the ethics rules. That's what he was yelling at him for. And I love how he admits that his motion was overlong.
Yeah. Well, and I mean, he's admitting, though, that he attacked these people.
He attacked the opposing counsel, which is against the ethics rules.
That's wild, man. All that happened was I was yelled at for having the audacity to drop ethical bombs. Later that session in the open court, when in light of the fact that the long delay of trial had already occurred and we were trying to move it up to 2012, it was determined that there were 2 openings on the trial calendar, one in 2010 and the other February 2011. He asked each side for a preference. We chose 2010 because we had a letter from the town of Bristol threatening foreclosure for accumulating back taxes if we couldn't get a judgment and have a way to pay them. He asked the other side's preference. Well, naturally, they said February the 11th, and that was the date that was given. We had withdrawn our counterclaims we were required to bring as a defendant after 3 years. There were no trial date in the place. It's now 2010, 2012 trial date wasn't even in place yet. I tried to go to federal court with our claims, withdrew over our claims, state court. Wow, this actually sounds something like we've seen too.
Mm-hmm. So he withdrew the claims from state court, tried to refile in federal court.
Yeah, we've seen this happen. Oh, man. Then opponent moved to restore our claims to state court, and we agreed to that restoration because the trial was now going to be moved to 2011. Well, Judge Shaven, even though they moved and we consented, wouldn't restore 2 of our 3 counterclaims to his state court docket, and he only restored 1 of them. That was the only reason we needed to continue to litigate in federal court when we had tried to get an earlier trial date because of those. That was the only court where those two particular things exist.
So let me get this straight. He pulled a fast one and removed it from state court, tried to file in federal court. And when he came back begging to be let back into state court, the judge was like, yeah, you can come back, but you're only coming back with 1 of your counterclaims.
Yeah.
Whose fault is that? It's his for pulling it from state court in the first place.
I mean, it's wild because I feel like we're on repeat of what we've seen. And
yeah.
I mean, it's the exact same thing, even down to the number of counterclaims.
Yeah.
Oh my God. So they consented, and he refused to restore 2 counterclaims. That's the reason why we had to litigate federal court, and the only reason. We had brought a motion for summary judgment. Oh, we've seen this.
Oh boy, here we go again.
And tried to authenticate an important letter accompanying tax payment, a letter of protest. Good for my opponent. I didn't cross with a T with authenticating affidavit.
Oh, so you screwed up. Is that
Yeah.
what you're saying? You screwed up, Bruce. You forgot to cross your T's and dot your I's. That's unfortunate for you.
But it's not his fault. He's like, this is,
It's never
remember,
his fault.
this is the fourth judge on this case. This is the same letter that had been submitted in 5 other filings before the judge along the way. Nevertheless, Judge Shaven considered authenticating affidavit in a reply brief to the new evidence and refused to consider the letter of protest, of which there was no issue of authenticity for the entire course of litigation. It was just an uncrossed T. Oh my God. Opponent capitalized on it, and Judge Shaven rewarded him for it.
All right. Hold on. I'm going to let you go, but I need to chime in a little bit.
Please.
You minimize a procedural mistake by saying it's just an uncrossed T, but by acknowledging that it's an uncrossed T, it was a faux pas. So it strikes me that whether you like it or not, Judge Shaben actually had grounds to make the determination that he made. That's my observation there.
I appreciate that.
It sounds to me a little bit, and I'm going to set aside the ethical bomb dropping because I'm not sure what the appropriate forum for those allegations was. But assuming that putting it in papers is appropriate, I can understand your umbrage in being chastised in chambers. But it sounds like it was in chambers and not outside in the courtroom. But what I'm hearing is that Judge Shaben inherited this. You were already very frustrated that that had been on the stove for 3 years. You have things that are causing your client problems because you have these tax liens and everything else going on, which is like sort of like waves undermining the sand. And so there's a lot of pressure on you to move this matter along. And he comes along and it's the complex litigation docket. It's a brand new thing for him. He's trying to get everything organized in a time frame. I understand you being frustrated at that point in time. But other than maybe being, chastised in chambers for something that he felt was inappropriate thus far, and I'll invite you to continue with the story. Thus far, what I'm seeing, and in my private practice, and I'm not in private practice right now, but once upon a time, I had PI cases where you rolled the dice, and if you win, you win. If you lose, you lose. I was involved in matters where we went to trial, expended a lot of time and energy, and ended up with nothing. I was in matters where, in fact, Judge Riley was here on the other side of some of the matters because he was in the defense and personal injury bar. And sometimes, and this was certainly not Judge Riley, but I would sometimes have cases where I would bump up against folks that I felt were extraordinarily aggressive, would throw everything at you, including the kitchen sink. And I was appalled. We had a theory. I come from North Central Connecticut. Our theory was the closer you get to New York City, the more you have to be careful because there's just different rules the farther south you go. We had almost a gentility of practice where you could do things on a handshake and a word up in Hartford County. You had to have everything in writing 3 ways to Sunday the further south you got. Now, whether that's a fair statement or not, I don't know, but that's the way it was for decades.
I appreciate that, Senator.
So I can definitely see, and for you to be here and to take this very seriously, I'm not dismissive of it, but I do see a situation where you're under a lot of pressure and he didn't create this pressure for you when he got involved in the matter. He had a lot of complex things. If you get asked to do this, you're going to do this because I found for good or ill that quite often judges that rise up through the appellate branch and maybe Supreme Court at some point in their career, they've usually had their hands around the complex litigation docket. Maybe not every single time, but I've seen it more than once. And so now, anyhow, go ahead. Please proceed. But just there are some things that I'm sort of seeing here.
That's funny, though. He didn't like hearing that.
Oh, yeah.
And I appreciate everything you've said, none of that really goes to what he did in the end, which was ignoring the law. But I'd like to continue because, my God, he's like, let me monopolize your time.
Right.
Oh my God. Because the point I was making was this new evidence in the prime brief was only half of the particular story, because what had happened was that whereas he wouldn't accept the authenticating reply, even just to say that the opponent, well, there's an issue of authenticity. If so, let me know. He let you know. He shot it down. He did. In January, they had filed a motion for sanction. Oh, look, they hit for sanctions again. Huh, that sounds familiar, doesn't it? And in open court, their attorney had said it's only limited to seeking attorney fees for state court, even though there's a federal court action we're going to deal with, and that's federal court separately. He shows up January the 11th. First time my co-counsel was with me on a hearing on motions of sanctions, and he says, hey, I've got 6 new cases here, and they're all support an argument that you should also award us our fees for federal court in the state court motion. And he said in open court, and I had the transcript, that he limiting our motion to state court fees. This is the same thing he pulled with Blvd. He was like, he promised us he would do it one way, but he did it another. God, he's like on repeat, man. Now he expanded it to the federal court fees, January 11, 2011, 3 weeks before trial date was to begin. Judge Shaven required us to submit in writing in response 6 hand-delivered new cases the day of the hearing while we were trying to prepare for the trial. Then he didn't rule on that motion for sanctions until 8 months later, after he issued the decision in the main case. That motion for sanctions hanging over our head affected everything we did, every decision we made, pre-trial through trial, post-trial. I'd love to be able to get you to postpone this vote and provide you with a couple of transcripts of an evidentiary ruling and a factual finding. If you read the full decision, his entire discussion on the key material fact issue is the weight of evidence is that Bristol Heights didn't tell Chicago Title that they were in need of refinancing a loan, which is the urgency of getting these tax liens paid off by a certain day. Attorney Dick Kuzmak, I almost said that wrong.
Oh my God, that's another terrible name.
I almost said that
Dick
wrong. That's what I almost said. Kuzmak. I was like, Kuzmak. That's what I'm going with. Kuzmak. Yes. Oh, you know your parents hate you when they name you that.
Dick Cumsmack.
Dick Cumsmack. A 40-year lawyer. God. He's in good standing. Oh, that sounds terrible too. In the state of Connecticut. I'm sure many of you have heard of and probably know personally. Oh, you know Mr. Cumsmack.
Everybody knows him.
Testified unequivocally, then specifically recalled on several occasions, telling them about the need to refinance a loan. And that's why we needed to get a clear title. Their witness on this point was caught by Judge Shaven seeking coaching from her attorney O'Hanlon. After answering a question of mine, she whispered, "Was that okay?" Coaching witnesses.
Oh, that's weird.
Let's see. So that's
coaching
bad?
Witnesses is bad?
I'll remember that. Okay. That's fascinating.
That's weird because he does that all the time.
God,
he
man.
did that with what's her name? Amanda
He's
Martin.
talking about transcripts and stuff. I really need to see the transcripts that he's whining about, because I would really love to see the transcript of. I'd like to see what he had to say about his opposition in this case too.
I would too.
Yeah, you know, that stuff's got to be fascinating. It's on the transcript. Miss Levi, you're not allowed to ask for confirmations if your answers are okay. And your counsel should certainly know better than to respond. Okay. Despite that incident, he believed her over attorney Cumsmack when she unequivocally testified that she didn't think he ever told her there was a need to refile a loan. Obviously, I'd remember that if he did. He implicitly found Dick Cumsmack, a 40-year lawyer in good standing in Connecticut, to have committed perjury. Without saying so in his decision. Wait, how do you find him doing it without saying
without saying so?
Yeah, that's. But if you read the transcript, you will read his decision that exactly what he found that Dick Cumsmack committed perjury. That didn't happen. Dick Cumsmack, he stands tall. I mean, all he believes, he
In
just
the,
blows
does he
the truth
stand?
everywhere.
Does he stand in the truth though? Is he standing tall in the truth?
Actually, other people stand in his truth. I don't believe for a minute that Judge Shapen believes he committed perjury. Well, he didn't say he did, apparently. Oh my
Yeah.
God! Now we're having some sex abuse stuff brought up. We're
Oh,
waiting
God.
for a hearing for January 11th. This isn't to do with our case. We're waiting for a hearing to be finished with the St. Francis sex abuse case. Attorney Bob Reardon. We have Reardon and Dick
And
Smack.
come smack.
Oh my God!
No.
This
And
sounds like
Pister.
what
And
kind of show
Pister.
have I? What show have I accidentally popped into
We've
here?
got Pister, Reardon, and come smack. This
Oh my
cannot
Lord.
be happening.
That needs to be a law firm.
Where
Oh
is
my
Jeff?
God!
Where's Jeff when we need him?
That
All
would be
these
the most
names.
amazing law firm ever.
Oh, Pister,
Oh,
Reardon, and
God.
come smack.
Oh Lord, that's so gross. Ugh.
Extra large and extra hard.
That's their slogan. Extra hard, extra large, and extra hard.
Oh my God. Who I'm sure you've most of you've heard of, was moving to disqualify a judge on that case before his opposing counsel had a spouse who appeared on the judge's spouse appeared on the opposing counsel's website as a consultant. Judge Shapen, he was hearing that motion and denied it, and then announced, we're waiting for our turn, and we're watching this. And then he announced, after denying the motion, that he was going to retire to chambers and consider whether to impose sanctions on Attorney Reardon, not because opposing counsel had
Reardon.
asked for it. he was going to Reardon.
Reardon.
Oh. They had, not because they had asked for it, there had been no motion. He denied Reardon's motion and then said, now I'm going back to consider whether to impose sanctions on you, Attorney Reardon. In the half an hour break, Attorney Reardon, as I understand it, gotten on the phone and lined up his own counsel because all of a sudden he's now facing a threat of sanctions that he had no inkling was going to ever happen. What the fuck does this have to do? Is this about, this has nothing to do with him.
A different case.
It's a case that has nothing, he's not even a part of. He's like, we're waiting for this abuse case to finish, and this is all about that case.
Yeah, okay.
What the fuck does this?
This is a totally different case.
Yeah, this has nothing to do. It's an anecdote, he said there. So you know that's just another anecdote that doesn't have to do with our case. But I think I would challenge anyone here who would, after today, if you postpone this vote, look at the entire record, look at the transcripts I've provided that have provided you. Read the whole decision. Have somebody you trust do an analysis of it. Question the matrix. And I would challenge anybody to conclude that by ignoring the facts and law in this case. The insurance policy provisions are undisputed facts. It's not facts that you can find or not find. Those are what we relied on for 5 years, and the law that governs the court's interpretation and construction of an insurance policy. We relied on that 5 years. We cited it, first paragraph of our brief. He cited it in his own decision 41 days earlier than our decision, R.T. Vanderbilt. It's all there. Acknowledged, cited, applied, analyzed. First paragraph of our brief, ignored in our decision completely.
Boy, he hates being ignored. You will not ignore me, Dan.
Yeah,
I will not be ignored, Dan. That's him.
That's what he's doing here. He's like, we lost and I can't stand it.
And now I'm going to boil your bunnies until you give me the attention I deserve.
No, he's going after a judge to make sure. He's like, you can't be appointed. You guys, you need to, because otherwise I'll harass you forever.
Forever. Yeah.
Well, we get 2 new law firms to file a motion for re-argument. They cite the new prior decisions. 2 of them, R.T. Vanderbilt and Pister from 2007, review the entire policy, interpret any ambiguities in our favor of coverage. He denied the motion for re-argument with 1 word. No decision, no hearing, no acknowledgement of any issues we raised, no acknowledgement of his prior
maybe your issues were stupid. Well, I wanted to make sure that you had an ample opportunity to explain. Have you filed a personal or have you filed a complaint with the, have you grieved Judge Shaben?
No, I have not. And I wouldn't have confided that I would not be just dismissed. Wait. And I wouldn't
have
confided.
confidence
Oh,
that
okay.
it would
For
not
confidence.
just
I
be
said
dismissed.
I was like, man, I misread a word. Okay, confidence. That it wouldn't just be dismissed. I have had some private discussions with people familiar with and possibly involved in that process, and based on that have chosen, at least at this time, not to pursue that avenue. He's saying basically, you're too corrupt. This judge is so corrupt, I can't get it done.
Well, it's true that filing a grievance against a judge
not gonna work.
it hardly ever does anything.
No, but it's amazing to sit here. Like what amazes me is the shit that he pulls here and then continue practicing. I mean, God, surely this affects your practice.
Yeah.
I mean, how does it not? You go in and you call judges liars and stuff. How does that not affect you?
It's terrible. Somebody in the chat, wait, who was it? I just lost it. Oh, James Rinkovich says the undisputed facts are the title insurance doesn't cover taxes. Yeah, that's true. That's true. Without even reading all the ins and outs of this complex case, I don't think that the unpaid taxes were the title company's fault. So yeah.
Well, what's
Okay.
crazy? I mean, he's talking about, again, he wants expedience in trials, and yet he does every damn thing he can to delay other people having that in their trials.
Right.
He was like, oh, we've been delayed years, 2007, 2008.
And
Well,
yet
I
that's
remember
what he's
somebody-
doing to Jeremy Hales.
Yeah, he delayed him. He bragged about delaying it for fucking 5 months. So
Mhm. Yep. You can start with Bruce in.
okay, give me a second here. There's been 11 junior judge disciples.
I thought that said disciples
I
too,
did
but it
too, for a minute. I
doesn't.
said, no, disciplines for the 1970s with the judicial review. It was all that EIO, and I call it the beginning.
Uh-huh.
Review Council has been formed in Connecticut 11 and 40 years, almost 40 years. In Arkansas, they have formed one in the early 90s. They've had over 100 judge disciplines. I wanted to say disciples. It doesn't seem to be an effective process for this type of misconduct. There's, drunk driving arrests and this and that and the other thing. This type of misconduct. This is the committee that needs to address it. What the fuck?
I got you, and you've made your case. And the last point is, and I just want to be clear about this, but you have gotten counsel to appeal this decision, and it's being reviewed right now.
The only way that was possible was for me to strenuously spend weeks recruiting. Oh, that sounds like somebody. Some
That's all
asshole.
he does.
Going out of my pocket to find somebody. An LLC can't represent itself.
I understand. Once upon a time, I had a client, and they wanted to sue Dun & Bradstreet. We did it on a wing and a prayer, and there's a decision out there. We weren't successful, but we brought it all the way to decision. Judge Cabranes. Cabranes?
Brain.
Oh my God.
This is
These
the
names.
craziest names, man.
Cabranes.
Pinky and Cabrain.
Pinky and Cabrain. Oh my God. And in retrospect, should we have accepted the offer that came 24 hours before the decision? Probably so. But guess what? That's what happens when you're in small practice firms and big practice firms. You get cases, you believe in the client, you run with it, you do the best you can. But thank you for your answers. Thank you, Mr. Chairman.
Thank you, Senator.
Are there other questions from members of the committee? Thank you, Mr. Chair, and good afternoon, Attorney Manskin. I can't believe somebody else wanted to ask him something.
Good afternoon, Rabbi. I'm sure he's harassed the shit out of them, so they're probably like, yeah, we're going to make sure that, we address this guy. That way he can't sit here and whine and pretend that we didn't.
Ugh.
I bet you that's what it's all about, though.
In hearing what you've had to say this afternoon, it seems to me that you're asking this committee to sit as an appellate court to make a decision that's already on appeal. I mean, we're talking about findings of fact. and we're not in a position to judge. We didn't hear the case. And as I was hearing what you had to say, I was wondering how you would respond to the question, what happens if on appeal the judgment is sustained?
Then I'll throw a fucking fit.
I'll throw
That's-
another fucking fit. Yep.
I know I've thought about that a lot, and the fact is that on appeal, there's appeal that's going to take a year and a half if you only get heard. And so, I wasn't going to forego a one-time and 8-year opportunity to address what I think is the serious issues that are documented here. What I found, and if you look in the part I left out from my reading, Larondo, another appellate court case this is not the question. He wasn't even asking anything like this.
I know.
This is the question. So that I was involved in a Fair Employment Practices Act case. We won a jury verdict. The judge didn't do a Lodestar award.
Yeah, I don't want to interrupt you, but I'm just wondering if you could answer the question, what happens if it's sustained on appeal?
I love it. I don't think that has anything to do with the issue I raised today, Representative.
Oh boy.
The issue I raised today are that a judge clearly known what the controlling law was for construing an insurance policy. He applied it a month earlier. It was cited. He knew we relied on that 5 years through a postponement. 2008, 9, 11, ignored it again on motion. They re-argue, including his own president, and then ignored it again in a motion for articulation. So whatever the appellate court can always find a way to finagle an affirmation. So he's telling you they're going to lose.
Oh yeah.
Right there. And that's what happened in the
FUPA
FEPA case, FEPA.
The FIFA case.
FEPA. They don't acknowledge
the less
their
known
own
cousin of the FUPA.
That's hilarious. They don't acknowledge their own precedent, which was no substitute for Lodestar. We cited, they upheld that the judge didn't even know.
Yeah. But with all due respect, I think that, there's a process in place. And if the appellate court does in fact sustain the decision, it has very much everything to do with it in my mind, because it would, I guess, in some measure, take a look at what you're arguing and say, well, Attorney Manskin, we understand what you're saying, but we don't find your side of the case to be correct. And we're going to rule the way Judge Shaben ruled.
I love the fact that this guy was just like, hey, I'm tired of hearing you just talk over everybody. I'm going to talk over you.
I'm going to talk over you. Yeah. So I think this, I think that has a lot of effect, and I understand why you're here. And this is an opportunity for you to let this committee know all about your little feelings and your experience with Judge Shaben. And certainly we appreciate that. But I don't know if we can sit and be the judge without having had the experience of hearing the case. I mean, that's what the appellate court is for.
That's very true, though. I appreciate that. I respectfully disagree, and I would like just to add that, that the Judge Shaben's decision doesn't enable the lawyers to even explain to their clients why. After 5 years of saying, well, look, we got to hang in there, persevere, even though they're hitting us with their resources and they're getting delays and they're getting special treatment to get postponement after postponement. God, this is the same thing. I hope, Lynette, I hope you're paying attention to this right here, because this is probably what you hear. You're probably hearing pled. No matter how bad it is, doesn't matter. Just hang in there. It's going to go over. It's all going to work out. These facts don't change because they're written policy provisions. I know how to read.
I can read.
Attorney Sullivan knows how to read. Attorney Jeff Tinley.
Oh my God, he actually said that. I thought you were making that up.
No, it says that. This whole paragraph, look. Attorney Jeff Tinley, who took this appeal for nothing, knows how to read. He knows what an insurance policy says because he can read it. He knows what the legal standard is.
Unlike John Cook, who cannot read words good.
That's so amazing. He can read. Wow. Hired, you are hired. When we're left at this point with no explanation why these policies or provisions exist, and this is the legal standard, we didn't get coverage because there's nothing in the decision to help us answer that question. Even if the appellate court upholds him, that doesn't change the fact that we're left here today. If he's given us the intellectually honest rationale, we might be able to say, gee, that's pretty airtight. Let's not waste our time for 2 more years on appeal. Let's not spend more money on new lawyers. Let's not continue to have Jada over
Ajita.
Ajita. My bad.
Ajita.
Fuck.
Yeah, it's Italian for diarrhea, actually.
It's loser for blah blah blah. That's what-
Apparently, he has bathroom problems.
Oh
He's got
my
agita.
God. I got the Ajita. It's
I
from
got
the
the
Mary
Ajita.
Jane. Over this for 2 more years after 5 years. He didn't even give us the opportunity to be able to understand what the rationale was, even though we've asked 3 times.
Thank you, Senator Doyle. Thank you, Mr. Chairman. I'm struck by your definitiveness when my colleague asked the question, if it's on appeal and it's affirmed, that I hadn't been able, if it's affirmed, that weakens your position, but you're so definitive that the judge was wrong. And it's hard for any of us up here to without, we're not a court of law and we're not an appellate court like others have said, but you and your response to us it's just so crystal clear that the judge was wrong. I would assume, and I was here for most of it, but I'm sure that he had a rationale for his opinion. Do you disagree that he had a rationale for his opinion?
Oh my God, man. Why I can't even imagine placating him. Yes, I do disagree. Because if you read the opinion, you'll see that he doesn't. You'll see that it's very frustrating thing is.
Well, you're saying so how did he write an opinion? What's the
Oh, so he gave a written decision, yes. But my point is the only way he could rationalize the decision was it did that by omitting 3 or 4 different specific insurance policy provisions and
all right, but everything, so you're putting us in a position to have to analyze it, but he did have a rationale. You disagree with the rationale, but the judge, he had some rationale, but you disagree with it. Is that correct?
I wouldn't characterize it that way. What I would say is the judge's rationale was egregiously incomplete under the law, notwithstanding.
Right. And then you're appealing. So you're appealing the case now. And if you're correct, his decision will be overturned.
Maybe or maybe not, but
well, no, if you're so certain you're right, it will be overturned.
Senator, I'm not so certain it's going to be overturned many times. Man, God, look at the way he talks to these people. Like he wants them to do something. They're not going to do what you want in this. There's no way in hell they would, by the way he's talking to them, because he's lost the plot. What I am certain about is there are 3 documents that show that the judge in July applied a legal standard and controlled legal standard in insurance policy claim. And in August, he ignored the same legal standard, even though the party he ruled against relied on it for 5 years and prominently cited it in the first paragraph of the post-trial.
Okay. Well,
that much I can prove.
All right. Well, but you also, do you have you don't have confidence in our appellate court that's going to be objective. And if you're right, I would think our appellate court's going to go with you in your, fantasy.
I sure hope so.
Well, I wouldn't hope. I mean, I have confidence in our appellate court.
I would like to have confidence too, and I had experience with the FIPA case in which I invested 3 years of my life for an indigent sexual harassment victim. Indigent again. Didn't get a fair attorney fee award from the trial judge. Cited Lorando, the appeals court prior. Lorando.
There's no R in that word. I don't know how you read
to
things.
I'm just adding words to it.
Lorando.
I put a P in it before. I was
Loranadonus.
Yeah, if you go, I went like Lauper. I went with Cyndi Lauper almost, Lorando. Lorando.
Does he
And
take up the rest of this damn hearing?
yes.
Oh
Yeah.
my, we've been going for 2 hours and 17 minutes and we are
Oh.
still not done.
Maybe we should take a break on it.
Should
The
take a
point
break.
is, though, if people don't know, like here, he cannot be wrong. And he went after another judge. He decided to go after them in a hearing with senators because he cannot take no. He will like this just shows you. This is why, again, I prepared everything because this douchebag is very Sue happy. He goes after anybody. I mean, they like to talk about Jeremy Hales being litigious, but holy shit, man, look at this dude.
It's incredible. And he's always complaining. He's always being wronged.
Yep, he's always fighting the injustice.
You know what? I'm going to let the chat decide what we do. Chat, do you want us to power through and finish the rest of this? If you do, send super chats and super tips immediately. If you don't send any, and we will end this shit show, as soon as possible. I'm going to read a couple of the super tips that have come in, and then I'll get to some of your super chats while we're waiting. You know what I'm going to do? I'm going to set a little goal on the super chats and I'll count your super tips too. Don't worry. I'll set a little goal. Let's see if we get, oh my God, is there even a goal anymore? What happened to the goal? Did they get rid of it?
I don't know.
Did they get rid of it? I think they got rid of it.
Oh my God, my legs are asleep.
Oh no. All right. If we get 10 more in the next couple minutes, we'll keep reading this. If we don't, we won't. I think they took the goal away. I don't see it anymore. Isn't that weird?
Maybe enough people weren't using it. I never used it. I just went with whatever.
I liked it. I kind of liked it. It was kind of fun.
I just never used it, so
yeah, if you want us to keep going, send the super chats, send the super tips, and in the meantime, I will read. We'll get a couple of these on here. Let's see the super tips that we have. We've got one from Snarkasm. Thanks for the 5. Oh, wait, I already played that one. Linda Allen, thanks for the 5.
I can't wait to see if my fake crying will work on the judge.
And Brazilla's Realm, thanks for the 5.
See a journalist completely lose it with laughter. Derailed on a YouTube law chat board near you. Yes, it's that Megan Fox. The giggle queen.
That Megan Fox.
She's the best.
Giggle queen.
The giggle queen. That's funny.
Thank you so much. I appreciate the super tips for show. Faux show. Okay.
Oh,
and we have super chats to get to as well. Let's see. There's a few of them here. Let's see. Max Lab. Thanks for the 2. The judge isn't right at all, Megan. Another stay. Well, I don't know. We don't know why he's doing it. If he's waiting for the motion. Yeah. If he's waiting for the motion to vacate, I think that's a legitimate reason. If he's doing it to give Lynette more time to get a lawyer, I think that's an illegitimate reason.
Yeah, I believe that's an appealable issue because, again, just
she
delaying.
fired her lawyer.
Well, and it shows bias is what it does. So he has to be real careful about stuff like this. Again,
Mm-hmm. Exactly. Maybe thanks for the 5. It's too late in the day to have that song stuck in my head. Fallen Hero 4567 gifted 1 Megan Fox membership. Welcome to the Fox Den. Whoever got that one. It's weird here, but you'll get used to it. Paul C, thanks for the 2. Appreciate you. David Meadows, member for 6 months. Megan, it may hit close to home, but look into what's going on with Buffalo, New York public schools and angry cops, cover-ups and lies, breadsticks for all. Thanks, David. I have looked into it, and it is very similar to what I'm dealing with. So yeah, it's just it's a public school problem, and it's not just in New York. I'm sure it's going on everywhere. Tracy Wilden gifted 5 Megan Fox memberships. Welcome to the Fox Den, all 5 of you. It's weird here, but you'll get used to it. And if you don't, well, bloody hamster heads in the bed if you try to leave. You know what I mean?
Did you see that article about the kid, like the little boy? He had buck tooth. Like, he was a cute kid, but he had glasses, big teeth. These people bullied him into ending himself. Well, apparently they not only did, I was reading an article on it. They went so far, and the schools did nothing about this, by the way. They went so far, though. They went to his funeral, took pictures of him, and
No.
posted them laughing at him.
No, Jesus
Yeah.
Christ.
Yep. I was like, are you kidding
Who are
me?
these monsters that would do such a thing? I do have parents, you got to do better than this.
I mean,
You
that's
just,
horrible. When I read that, it was soul crushing. You know,
it's
the
horrific.
parents did interviews, and I was like, oh my God, you know, you really felt for them because they were just so lost in that. And they had asked for help. They had been asking the schools, and the schools did nothing about it. They did absolutely nothing.
horrific.
Yeah, but it was so bad that some of these people that had been bullying their kid, they showed up at the funeral. I was just like, oh my God.
I can't see people like that should go to jail. That should be an instant.
Oh, yeah.
You should be arrested for that. That's crazy. And by the way, you can go after people for facilitating suicide. So, you know, they should consider doing that because that is horrific. Carol Welsh, thanks for the 2. Russ didn't show up at town hall to be sworn in. That is so weird.
Really?
What does that mean? Is he not sworn
in? What
in?
does that mean?
I'm going to have to look into that. Rach G, thanks for the 10. I feel for you, Megan. My dog got really sick on my hardwood floors. I'm going to have them refinished because it stained the wood. Oh, I hate seeing poor pup sick. That's why he's locked in his room because his room has stone tile, so it's much easier to clean. And he likes it in there because the floor is cold. Rach G, thanks for the 2. Tug needs an AI of Umbrella frantically typing. That's funny. Jackie Hampson, thanks for the 5-pound super sticker. Appreciate you. And Buck Naked, thanks for the 5. If he was winning all these proposed suits, he must be a billionaire. Yeah, right. Slug Entertainment, thanks for the 2. Grandma owes me a bottle of Bacardi. I don't know who your grandmother is, Slug, but I hope you get that Bacardi soon.
That is a good point, though. All these lawsuits and stuff. Why isn't he just rolling in the funds?
Yeah, why not? Why isn't he? That's a very good point. Green Veggie Beast, thanks for the 5. Why do I keep seeing monkeys? I don't know. Sounds like a personal problem. Maybe something you should discuss with your doctor. Kay Kirkpatrick, thanks for the 2. Puff, puff, hold pass. Need a 15-minute break. Green Veggie Beast, thanks for the 5. Just in, Lynette has hired new lawyers. The firm of Ben, Dover, and Hard is taking her case.
Dick Comstock is filling it.
Dick.
He's filling in. Oh, no.
And SF, thanks for this $5 super tip.
Need more of this. Like, I need more twins.
And Puzzled Puzzler, thanks for the 5.
I've now decided to hire the Three Stooges law firm of Dewey, Cheatham, and Howe.
That would be just perfect. But that's it. We have reached the end, and we did not get to the 10, so I think we're going to call it quits. And I'll read through the rest of this.
By the way.
Oh, good. We did. Oh, what did I? Where did
that super chat in there?
Oh, yep, we sure did. Okay. Be the bland one, thanks to the 5. Megan, now we know why BBB doesn't like you. Prior Fox encounters. Yep. True. Yep. And Gamer Jackie, thanks to the 5. Captain Corey's mom, Pixie, has been no way. Harassed by a crazy Amber Heard stan as well, making spoof accounts and bad captions with photos of Corey. Oh my God. Point me in that person's direction.
They've been so insane lately. I mean, it's unreal, like some of the stuff they've done. I mean, you have to remember we're what, 3 years now after the fact, and they're not just trying to relitigate, but I mean, they are going after people, trying to pay people back. And yeah, I mean, them going after that family, that's horrible. You know, it's just a little kid it's just a little kid who liked a character.
Like Johnny Depp. I mean, come on. And George Despo, thanks for the 2.
He didn't really like Depp, though. He liked a character.
Captain Sparrow. Yeah. Right. All right. Since you guys said we're halfway there, so I'll tell you what, we'll read another page. How about that? All right. You left off right here. So I
don't know. I can't say where's here.
Oh, right here.
Okay, I was like, "Where's here?"
Sorry, I thought I thought I highlighted
it. So my shake faith. It's not like a shake weight in the appellate court is a little bit shaky based on that, and frankly, We should be in a very different position today, whether we lost or won with Judge Shaven. We should be in a position to know whether the specific policy regulations that we relied on play into decisions and how the legal standard that controlled his interpretation of this insurance policy played into the decision. We don't have the benefit of either of those two intellectual understandings.
Thank you, Mr. Chairman. Thank you. And there's a few other legislators have questions. I just want to follow up.
Why?
I don't know. I just want to follow up on what Senator Doyle was just asking about, though, with respect to the appeal. When you're appealing a case that involves an insurance policy, the policy, of course, is part of the evidence, and the language of the policy is there, and the appellate court will have an opportunity to look at the language specifically. It would mean, as a general rule, that the trial court would establish the facts and the appellate court would review the law, that the facts that they were established during the trial. But when you're dealing with an insurance policy, you're saying that the language, a plain language of the policy, was somewhat ignored. Is that essentially? Is that it?
Man. It was completely. It was ignored completely.
Okay, that's what you're saying?
Yes.
And then you're also
for 4 different provisions.
But the appellate court will have an opportunity to look at that.
They will have an opportunity to, yes.
And you'll have an opportunity, or somebody will have an opportunity to argue that this is what, I'm to argue that.
Yes. But that does not resolve the issue I raised today quite respectfully. He has to be like, I raised it quite respectfully, by the way. I just do not think that this resolves these issues.
Well, no, but there's also the law that will be applied. And if the trial judge either applies the wrong law or ignores the law, the appellate court will have an opportunity to address that.
They will, right? But again, that's 1.5 years from now. And I'm concerned today that you're about to reappoint somebody for 8 years who has blatantly come out essentially and said, I, a judge, have the option, the discretion, the power to choose to apply the law if I feel like it, and then a month later to ignore it. I don't know why. Is it for the party's benefit or not that one or that counsel's benefit and not that one? Okay, I see what he's saying. It's for them, not this one, that one, not this one. I got you there. He applied it and then he ignored it. And that's a serious issue. And I would like to just read a very short excerpt from War and Peace. From one incredibly telling evidentiary ruling in a trial that goes back to, the cumulative effect the Senator Kissel asked me about whether I felt that, getting off of the wrong foot, may I?
How short?
Oh, short. It's very short. It's like my micro peewee. 1 minute. That's all I can manage. The issue is.
No. Actually, I'm not sure I want to listen for a whole minute. This is why he hates me. This is Representative Fox.
Oh, shit.
I love this person. Who is this hero? I have to look this up now. Who is Representative?
Oh, my God. He just put the flamethrower into old man's skin.
Connecticut. I'm not sure I want to listen to this for an entire minute. Oh, my God. It might be a woman. I can't tell. There's 2.
Oh my God!
So there's an Ellen Fox. There's an Ellen Fox that ran for Connecticut House of Representatives. But there's also a Dan Fox from Stamford.
I think it might be so much.
I think it might be him. I think it might be Dan Fox. I need to know who this hero is.
Like, I don't want to hear this crap.
Yeah, he's like, no, I'm done. I'm done.
Good.
I can't even.
Thanks, though.
I can't even listen to you for 1 more minute. Nope, not even a minute. How short? Yeah, that's not short enough. God, I like this guy. Look at this hero.
This dude
I don't know.
is a hero, man.
This dude he's brutal, savage. I love it.
I definitely can appreciate that, though. You know what I mean? I definitely concur.
I also concur.
Yeah,
that
what
was
a senator,
absolutely
man.
Hilarious. That was really funny. No, I mean, not not you. What you can do is, if you like, you can. Have you handed it out to us already?
Well, not this particular thing.
Okay.
Representative O'Neill got it in a long email. Oh God, can you imagine what he considers a long email?
No, I can't. Well, then maybe if you like, what you can do is, if you can.
He ruled the word "no" was nuisance in order not to sustain an objection.
That says nuance.
No,
The word
whatever.
no was nuance.
No, nuanced. I don't know.
No. And I also don't want to cut you off. If you'd like to hand a copy of it to somebody, we can get it, make a copy.
I feel like I've read like a 40-page filing of Bruce words. I'm like, oh God, it's like word vomit in my brain. My brain's starting to shut down.
There will be a short break between, where you can go smoke the devil's lettuce after the public hearing.
I might need some devil's lettuce, man. What's up?
We're all going to hit the bong after that, and then we'll be back. We can get to it, everybody, so they can take a look at it. I just don't want to, if you don't mind, I'd rather not have you read for a minute.
This person is a damn hero. He's like,
He's
absolutely. I
He's
appreciate
a damn
it.
hero.
He is, man. I mean, I swear, if I could vote for this person, I would.
I would, just for this alone.
Mm-hmm. That's all
Now
it
we
needs.
have Representative Barham. A couple of questions I wanted to ask just to clarify some information that you've conveyed. You said that you've been litigating this case for 5 or more years, but those 5 years were not all before the same judge. Is that correct?
That's correct. Oh my God. It started in New Britain, filed as a declaration action by an insurance company in March 07. Then it was scheduled for trial September 08. I got hired in 08, relying on September 08. A week before it got postponed at their request, the opponent's request, 09. Before July 09, it got transferred to complex litigation. So it went before Judge Trombley to Hartford and Judge Shortall. Oh my God.
Or if you read it, it could be Short Tall.
Shortall.
Short Tall.
That's true.
Judge Shortall.
Dick
That's
comes
funny.
back and Judge Shortall. Oh my God, man, there is a cast of characters here for sure.
Oh my God. Okay. My point though is that you're not blaming Judge Shaben for the delays that occurred prior to his involvement in the case.
It's what it actually feels like, doesn't it? Representative, I'm not blaming him for that. Although I think that it's a significant the way that transferred, and then we got it transferred, and the overall picture here is that it seems that been singled out for some incredibly prejudicial actions that don't happen in other cases.
Well, it sounds like your anger is directed toward the judicial system or process more so than perhaps a particular judge.
Well, if the decision had ignored the law and the facts, God, don't you hear me? Holy jeez, I'm always right. Then my anger would only be about the delay.
So you would still be angry.
It would have been a sausage. A sausage. Because
I heard that attorney
Cum
Cumsmack does a lot of that.
I love it when he sausages the facts. Would have been applied.
Oh, wait a minute. The chat has found another Fox. But see, no, it wasn't a senator. It was a representative. So it's not Virginia Fox because she's a senator. It's the representative. So the guy who's a representative in the House of Representatives in Connecticut, not in the Senate. Some of these are senators and some are representatives. So it's Representative Fox, whoever that is. I think it's Dan. Well, now, when you claim you didn't get the detail in the decision of the judge, did you file a motion for articulation?
Yes. I recruited and handled 2 law firms, respected, Tinley, Nastry, Reba, whatever, Doss and Waterbury, Dornberger, Sexy, Vita. Just throw some words in there.
Dornberger,
File a
Sexy,
motion.
and Vita.
for a re-argument, an extensive and expensive motion for re-argument. Going through, I thought he said he'd only had a little bit of money to spend now. So that was expensive.
I don't know. I don't know.
Going through the issues, legal authority that the judge had not touched on in his decision. He denied it with one word. What was that word, though? Denied.
Denied. Yeah, it was this.
Denied. Sit down.
How come you didn't file the motion yourself?
Because they're in the back of my mind. I thought it might be something to do with me.
Yeah, because everyone hates you.
Hates him.
Because everyone hates you because you're a bad man and you treat everyone with disrespect because you're nasty and you're contentious and you're argumentative maybe, and you also apply the law incorrectly and you cause people problems. Maybe that's why. Yeah. And one last question, you keep referring to the legal standard that the judge had issued a legal standard previously in the Vanderbilt case. I think you're saying. But don't you agree that when you apply a legal standard that you have to apply the facts to the standard, that even though you have a rule of law, the facts may or may not fit that particular rule of law in any given case?
That's true. Yes, but in insurance policy case, there's one legal standard that's been well worn and well established, well recognized. It's boilerplate. Man, he knows about boilerplate.
He knows about that. Yeah, he does.
And the judge relied on himself. There was insurance in Vanderbilt.
Our dilemma. Well, let me ask you this question then. The opposite side, I assumed that they filed a brief. And did they stipulate to this legal standard or did they dispute it?
No, they certainly didn't dispute it. I would imagine they probably did quote it, at least a part of it. But they certainly didn't argue against it by any stretch.
Well, did they agree the facts fit this legal standard, or did they find some distinction?
No, they certainly did. The legal standard is twofold. A court has to decide an entire policy, and then any rational construction they would favor coverage has to be adopted. So if there's like this section seems to be like there's no coverage, but then one seems like there is, the legal standard requires the judge to find coverage from that ambiguity.
Well, that's what I'm pointing out, is if the other side agreed with your arguments, there'd be no controversy in this case. The judge would say, we have an agreement. We have two sides who both say there should be coverage.
Indeed. Right.
Obviously, they didn't do that. They felt there was some other interpretation.
I mean, look at all, but their brief, the argument, Dick, come stick, but didn't address the section. Yes, but they did explain why in the or maybe did. But God, that's a mess. You could tell.
Or maybe they did.
You could tell he was like, holy crap, it messed him up there. Maybe they did, but the point is that in the final decision, the judge didn't acknowledge this section we relied on, and the legal standard requires the court to view an entire policy recognized by Judge Shaven in 2000 decision called Pister. Pister. And that rational construction in light of the entire policy is in favor of coverage if it's rational to do so, when he recognized in July of 2011, 41 days before he issued the decision. Now, our briefs have predated Vanderbilt decision, but his decision in the case came after the Vanderbilt decision. That's why we did our motion to re-argue, and we signed it for Judge Shaven. His own prior decision in Vanderbilt in Pister, and he denied that motion with one word: no hearing, no discussion. He just was like, "Oh, fuck you, Bruce, you piece of garbage." And I was like, I would even make sweet love to you if you listen again. But no, there was no post-trial, nothing. It was all
I even agreed to read him, but it didn't go anywhere.
I told him I wrote it in my briefs, and he was like, what?
Old Line Red said, this is what happens when a lawyer tries to BS a committee made up of other lawyers.
Yeah. They're starting to ask him. You could tell he really got flustered on that one. He was like, wait, what? Did you ask me something?
And George Desco sent a bunch of super stickers here. Thank you very much. And your mom 95977. Thanks for the 5. Looks like Senator Fox is female. Virginia Fox still serving, except this was the representative, so I don't think it was her. Crystal, thanks for the 2. BBB needs to go before Howie Felter snatch. Oh, who's Felter?
Oh no! Howie Felter.
Felter snatch. You got me. You got me.
That's
Jamer
good,
Clay,
actually.
thanks for the 2. Just sent you and Tug an email with the screenshots. Screenshots of what? What screenshots? Oh God.
got
Do I
screenshots of-
dare? Do I dare ask? What are these screenshots of? Oh, of Corey. The harassment of Corey.
Oh no.
Okay, good. I'll take a look at that. But
Yeah,
my
I'll definitely
God,
look at it
what a
too.
bunch of assholes. Jacqueline Weaver, thanks for the 5. Better be careful or Megan's panty hamster will start screaming. This is also true. There are no super tips to hit. So let's go back to this because this is getting hilarious. Let's see. He was just talking about writing on his briefs. There was some kind of writing in his briefs he wanted these people to see. Representative Gonzalez is now stepping up to the microphone. When do you file?
This is horrible, man.
What? Oh, no, don't look at it now. It's
Oh,
just going to upset
God.
you. Don't look at it. Good God, don't.
Oh, I'll get on that tomorrow.
Oh, my God. I can't
Yeah,
look at that.
The images. I'll look
my
at it tomorrow for sure. I will,
God.
but tonight I'm not going to do that. Okay, I'm not going to get into it tonight.
Oh, Jesus. I can't
That's
even.
awful.
People are sick. Those
Well,
people ought to be arrested.
these people are attacking because they simp a person that was found to be guilty, and I think the world found them to be guilty, but they can't stand that idea. They can't, So what do? They attack a grieving mother. They send them
Sickening.
horrible pictures. I just, oh God,
Absolutely sickening. Did you file a complaint against the judge?
oh, I was making pictures. What you're reading.
It's okay.
Did I file a complaint against the judge?
Uh-huh.
No, I'm not, Representative.
So you have not.
No, I'm not. I chose this avenue to pursue these issues.
And this to the appellate court. This is
The case itself is on appeal. Right now, lawyers are handling the appeal on the case of merits.
okay, but my question is, because I'm not a lawyer, but my question is, did he know about this, that you have a case in the appellate court?
Certainly, yes.
So he knows that.
Well, why would that matter, actually? I don't understand.
I don't know. This person is not a lawyer and she's asking stupid questions.
Oh,
or
yes, that would.
And when did you went to the appellate court? When did you file?
The schedule, that's what's called the pre-argument conference. I think it's been going in April. Then there's a brief schedule, which is several months long. There's probably several more months. It's scheduled for hearing, several months before I hear. Oh God, several months to get this. You may think I'm joking but that's how it reads, by the way.
No, he really said that multiple
Yeah.
times.
I estimate a 2-year process.
So when do you want to refile that?
It's
Oh,
filed.
this person has no idea what this is about. When?
No. They don't understand what's going on. Oh, it has to be filed within 20 days if decision came. So it was filed, several weeks ago.
Several weeks ago.
Yes, we did a motion for you to argue, and after it had been denied, so several weeks or a month and a half ago, roughly. I don't know the exact date it's filed.
Okay, thank you. And then
They
we have
had no idea what they were
representative-
asking.
Yeah, that
They
person
just-
had no idea what they were asking.
I think they asked so he would stop bothering them, probably.
It
know.
may be. Representative Albus, thank you, Mr. Chairman. Thank you, Attorney Madskin, for taking the time you came up here today. We've talked a lot about the relevant cases in regard to your testimony, but is there anything regarding Judge Shaben's demeanor that you think the committee should know about?
Yes, of course.
Oh, Jesus, look at this. Lord save me. Lord,
I'm saying
sweet baby dumpster
we should
Jesus,
stop, because
please
there's
come.
a lot more.
There is a
There's
lot more.
Well, yeah.
How
I
can
mean,
this-
for it, look where the little
He
dividers.
has
Like, what,
hijacked.
yeah. What
What?
page is that, by the way? 80.
It was
the
90.
little. You know the little
We were on-
scrolling thing on the bottom or on the side. You see how
Yeah,
far
but
it
I
is
thought
away?
for sure. I thought for
No,
sure that there would be
no. There's
something
more.
else.
I was scrolling this.
This
earlier.
is all him.
Yes, look at it.
Oh my
Yeah.
god!
Yeah, so we can't finish it.
No, we
We
can't.
get her for like 4 or
For-
5 more hours.
Oh my god! Look at this. He hijacked the rest of this hearing until page 111.
Mhm.
Oh my god!
That's amazing, isn't he? He hijacks a whole hearing and makes it about Bruce.
Oh, and then the next guy who speaks is in support of the judge.
See,
Interesting.
I think it'll be fun to go over. But
Yeah, we will have to pick this up on another day. I didn't know that it went that long. I didn't know that it was
yeah,
that.
yeah,
I mean, my
it turns into a
God.
whole ordeal because he's going out of his way. I mean, you got to think of the seriousness of this, and he has brought up something to the point he's hitting up senators. I mean, we're talking about going to some of the highest legislators out there and complaining because he did not win a case. Now, again, I'm not saying you can't do that. You have every right to do it. But my God, you know, the way this guy does, he does this all the time. He's a very sore loser.
Oh yeah, very very sore loser. This just in, breaking news. Apparently, Lickman says he's going to sue J-Hip. That should be hilarious. Dickie Lickman is going to sue J-Hip.
Oh
Just
my
J-Hip.
God. So I thought he was like this big monster troll, though, that like put everybody in their place. And he is fucking J-Hip, like, is broken him already, really?
Yeah, I guess.
Oh my God.
Yeah. So, yeah, that's interesting. Brad Stutler, thanks for the 20. I appreciate that. And Brad, again, thanks for the 5. Do you think it's possible Judge Blytho has researched into Manskin's history of court shenanigans? I would be very surprised if he hadn't.
I doubt it. I don't think he has. I don't. Like,
Oh, I think he got curious.
Maybe now. I don't know. I mean,
If okay, I'll put it this way. If he's planning on sanctioning him hard, he did. He looked into disciplinary history. He did. He looked into it. If he's not going to sanction him, then no, I don't think he did. I think it's possible. It's Schrodinger's research.
Schrodinger's sanctions.
It's Schrodinger's sanctions. Exactly.
Yes. You know, if I look at this case hard enough with the docket closed or open, do the sanctions actually exist? That's funny.
Oh my God. And we've got one more super tip to close out the night from Becky Fearwreck.
Gotta love my lawyer. Not my lawyer has briefs, but not briefs.
All right, everybody, you need to go and say hello to Shizzy Wisnut and please apologize to him for how long we went tonight. He is going over the Laura Owens case. He is revisiting the Laura Owens trial, I believe. So you go over there and tell him that I'm very, very sorry. We went so long, but we had no idea that this was that.
Yeah, we had no idea how we
freaking
were stepping
long.
into. Yes.
Yeah.
Tomorrow, join us over. We will have fun. We will go over
It's Tug's
something.
birthday.
That's right. Come with your celebration time.
And all your birthday songs, get ready to sing and make sure you bring gifts and gifts in the form of breadsticks. And we will have a riotous time on Tug's channel tomorrow. So see you guys. Good night, everybody. Good night, Tug.
Later.